Bien, mesdames, messieurs, je vous propose que nous commencions cette session en respectant strictement les délais, car on sait bien qu'en matière d'environnement, être au rendez-vous de la trajectoire, c'est absolument essentiel. Mesdames et messieurs les chefs et juges des cours suprêmes, et mesdames et messieurs les directeurs d'administrations européennes, mesdames et messieurs les magistrates, les magistrats, chers collègues, chers amis, il me revient ce matin l'honneur d'ouvrir ces 2 journées du Forum des juges pour l'environnement, consacré aux droits du climat et aux contentieux qui en découlent. Permettez-moi de vous renouveler mes mots d'accueil de bienvenue au Palais Royal, au sein du Conseil d'État. On est très heureux et très fiers de vous accueillir aujourd'hui. Je vous remercie très sincèrement de votre présence. Et je tiens évidemment au premier chef à saluer votre président, Luc Lavridsen, que j'avais eu le plaisir de rencontrer à Paris en février dernier et que j'ai également le plaisir de retrouver aujourd'hui, et Farah Boukel, qui le seconde avec une admirable disponibilité. Je souhaite également adresser mes salutations à 3 orateurs en particulier, parmi tous ceux de très haut niveau qui interviendront aujourd'hui et demain, et j'espère qu'ils m'excuseront de ne pas être tous expressément cités. Monsieur Herman Benjamin, qui vient du Brésil, dont la renommée a franchi l'Atlantique, l'ancien chef justice irlandais Frank Clark, que je salue à nouveau, et le juge tchèque du tribunal de l'Union européenne à Luxembourg, Jan Passer, dont nous connaissons le rôle cardinal qu'il a joué durant la présidence tchèque de l'ACA Europe. Et donc voilà, soyez particulièrement remerciés. L'émergence du droit de l'environnement ajoute une dimension aux autres droits. Ainsi, le droit de la commande publique le prend en compte, par exemple avec la possibilité d'introduire des clauses environnementales. Le droit pénal comprend dorénavant des infractions spécifiques importantes liées à la protection de l'environnement. Le droit minier inclut de plus en plus de normes destinées à sa protection. Et d'une manière générale, le droit de l'environnement se décline lui-même en de multiples droits destinés aux réglementations, législations destinées à préserver la biodiversité, à préserver un environnement sain pour la santé des riverains ou encore, et c'est le droit climatique, évidemment à lutter contre le réchauffement climatique, voire à permettre l'adaptation de nos sociétés au dérèglement en cours du climat. Alors, ce droit climatique a connu ses prémices au sommet de la Terre en 1992, traduite évidemment dans la Convention cadre des Nations Unies sur les changements climatiques. Il permet de préciser le droit, voire les obligations en matière d'action contre le réchauffement climatique, largement jurisprudentiel et défini au gré des instances introduites devant les juges. Ce droit a été progressivement précisé avec la multiplication des initiatives internationales et européennes, tournées en particulier vers les objectifs définis à la COP21 dans l'accord de Paris. Ce droit que l'on va examiner aujourd'hui dans ces travaux est toutefois encore appelé à évoluer. Le caractère global du dérèglement climatique et le caractère en particulier jurisprudentiel des avancées rendent particulièrement nécessaires, me semble-t-il, les discussions des juges de l'environnement, entre eux bien sûr, comme aujourd'hui, mais aussi avec les autorités politiques et administratives, notamment européennes, qui traitent de ces questions. Le réchauffement climatique transcende en effet les frontières, tant dans ses causes que dans ses conséquences. Il invite à penser ou repenser la souveraineté, pour reprendre les mots de la professeure Mireille Delmas-Marty, non plus comme solitaire, mais comme solidaire. Plusieurs modèles existent pour préserver l'environnement. Il est possible de le protéger en consacrant des principes de droit au niveau le plus élevé, avec par exemple la constitutionnalisation de grands principes destinés à préserver l'environnement des atteintes humaines. Mais la protection peut également venir de la monétisation des externalités qui découlent de l'action polluante, avec notamment le principe bien connu du pollueur-payeur. Ces différentes voies qui dépendent de l'architecture juridique et de l'interprétation des États sont autant de sources de discussion entre les juges. L'engagement résolu à l'échelle européenne vers la neutralité à l'horizon 2050, avec en particulier une réduction des émissions nettes de gaz à effet de serre d'au moins 55% d'ici 2030 par rapport à leur niveau de 1990. Le paquet législatif Ajustement à l'objectif 55, présenté le 14 juillet 2021, rend nécessaire un travail commun à tous les acteurs. 2 réflexions ce matin en introduction aux travaux fructueux qui vont suivre. Premièrement, le droit climatique est un sujet d'intérêt commun, je crois, bouscule nos cadres juridiques et appelle à des actions qui devraient toujours prendre en compte les autres États. D'abord parce que le droit climatique a compris dès l'origine des éléments d'extranéité qui invitent au dialogue des juges de l'environnement. Ce droit s'est d'abord construit comme un ensemble de règles appliquées dans un cadre frontalier clair. Le droit climatique, au contraire, a eu tendance à recourir à un cadre plus large durant son développement, non seulement à partir des lois et règlements nationaux, mais également de manière conventionnelle et jurisprudentielle. Cela a conduit, vous le savez, à des décisions dans plusieurs États, inspirant les juges par-delà les frontières de chacun des pays. Pour faire respecter les engagements internationaux, les juges ont, un peu partout dans le monde, vérifié les actions des autorités publiques, contribuant progressivement à l'émergence d'un véritable droit climatique. Chronologiquement, l'affermissement du droit climatique commence sans doute aux États-Unis avec l'arrêt Massachusetts contre US Environmental Protection Agency, rendu par la Cour suprême le 2 avril 2007, qui a marqué le début du mouvement de judiciarisation en cette matière et posé les bases de la stratégie contentieuse, à savoir l'action devant des juges d'agences et d'associations afin d'obliger les États à agir pour réduire ou atténuer les effets du changement climatique. Aux Pays-Bas, la Cour suprême a reconnu l'existence d'un consensus scientifique sur la gravité du changement climatique et, par voie de conséquence, ordonné au gouvernement néerlandais, sur le fondement des articles 2 et 8 de la Convention européenne des droits de l'homme, de diminuer de 25% les émissions de gaz à effet de serre. C'est l'affaire très connue Urgenda qui sera analysée aujourd'hui. Dernier exemple, plus récent, le 30 juillet 2020, la Cour suprême d'Irlande a annulé le plan de lutte contre le réchauffement climatique du pays, jugé insuffisant ou imprécis. Le programme de l'ONU pour l'environnement faisait état en juillet 2020 d'une importante augmentation des litiges depuis 2017, avec en 2020 plus de 1550 procès liés au changement climatique, contraignant toujours plus d'États et les entreprises à se doter d'objectifs et à agir conformément aux engagements internationaux pour atténuer ou s'adapter au changement climatique. Cette implication très forte des juges, qui sont les garants des engagements consentis par les États, est, me semble-t-il, un signe de maturité de la réflexion autour du droit climatique. La discussion d'aujourd'hui permettra d'en prendre la mesure et d'en apprécier la portée. Deuxièmement, par son caractère global, le droit climatique pose des questions très nouvelles. Il s'agit tout d'abord, évidemment, de concilier ce droit avec les autres droits, et singulièrement avec les libertés publiques et les droits fondamentaux. Cette conciliation s'est faite autour du concept de justice climatique, c'est-à-dire du rapprochement de la lutte contre les inégalités et contre le dérèglement climatique, ce dernier pouvant aggraver encore les périls qui pèsent sur les plus démunis. La justice climatique porte toutefois en son sein les problèmes pratiques et théoriques de conciliation des différents droits auxquels je faisais référence au regard des espèces particulières portées devant les juges. Une illustration de cette nécessaire conciliation des droits fondamentaux traditionnels et de ceux liés à l'environnement a été donnée par la décision du Conseil constitutionnel français le 31 janvier 2020, qui a estimé que la protection de l'environnement pouvait justifier des atteintes à la liberté d'entreprendre et qu'ainsi une loi pouvait interdire aux producteurs de pesticides français d'exporter vers des pays tiers des produits contenant des substances prohibées par l'Union européenne. Cette nécessité de conciliation se retrouve dès la Charte française de l'environnement, qui a valeur constitutionnelle et qui invite en son article 6 à la prise en compte par les politiques publiques des divers objectifs que sont, je cite la Charte, la protection et la mise en valeur de l'environnement, le développement économique et le progrès social. Troisièmement, conceptuellement plus délicate encore, de nombreux litiges posent la question de la conciliation des différents droits de l'environnement entre eux-mêmes. Il peut en effet exister des conflits entre les normes selon leur source ou selon leur domaine. Les différents droits de l'environnement trouvent, vous le savez, en effet leur source dans les corpus nationaux, les corpus internationaux, et en particulier dans ceux de l'Union européenne, voire pour certains, dans la Convention européenne des droits de l'homme et des libertés fondamentales, telle qu'interprétée dans la Cour de Strasbourg. À cet égard, celle-ci se prononcera sans doute sur la portée de la Convention en matière de droit de l'environnement, dans une affaire de Arte Agostino à venir, face aux multiples saisines dont elle fait l'objet. Ces saisines posent d'une part des questions de fond sur l'extension raisonnable des stipulations des articles 2, 3 et 8 relatives au droit à la vie, à l'interdiction des traitements inhumains et dégradants et au droit à la vie privée. Ces questions portent d'autre part sur la juridiction, au sens même de cette convention, c'est-à-dire sur la recevabilité des requêtes face à un phénomène global dont les responsabilités sont partagées, y compris avec des pays qui ne sont pas partis à la convention. Les droits de l'environnement doivent également être conciliés entre eux d'un point de vue matériel. Ainsi, pour protéger le climat, le déploiement des énergies renouvelables est nécessaire. En pratique, ce déploiement peut heurter certaines dispositions protégeant la biodiversité, par exemple du fait de l'implantation d'éoliennes ou de panneaux photovoltaïques dans certains milieux. Voir par exemple, le Conseil d'État, dans sa fonction consultative, s'est prononcé en septembre 2022 sur le projet de loi relatif à l'accélération des énergies renouvelables, pour lequel cette question se posait. L'urgence peut également conduire à ce que soient mis des limites à l'exigence de la participation des citoyens aux décisions environnementales. Ce travail de conciliation sera d'autant meilleur qu'il s'appuiera sur un dialogue des juges, qu'il s'enrichira des exemples de chacun de nos pays et de tous ceux qui édictent les normes. Deuxième remarque, pour ce qui concerne la France, le Conseil d'État et plus largement les juridictions administratives prennent part très directement, très délibérément, avec beaucoup de volonté à ce développement du droit climatique. D'abord parce que les questions du droit climatique qui s'inscrivent dans le développement du droit de l'environnement se posent avec toujours plus d'acuité pour la juridiction administrative en France. Le Conseil d'État a eu très tôt à prendre la mesure des questions liées à l'environnement, avant même d'ailleurs l'émergence d'un droit environnemental proprement dit. Son rôle dans l'application et l'interprétation de la réglementation très ancienne, relative aux manufactures et aux ateliers insalubres ou dangereux, a conduit dès 1860 ou 1887 à des décisions en cette matière dans le cadre du développement de ce qu'on appelait l'hygiénisme, ce qu'on appelle aujourd'hui la santé publique, et qui imposait de connaître déjà des questions de cette nature. Les concepts classiques du droit administratif ont été imprégnés au fil du temps de considérations environnementales. En témoignent évidemment l'enrichissement de la police administrative générale et la multiplication des polices spéciales qui ont pour vocation de faire respecter l'environnement. La reconnaissance de missions de service public de nature environnementale, comme celle qu'assurent les départements dans la protection des espaces sensibles, a été confirmée à nouveau en 2007 par le tribunal des conflits. Et cette reconnaissance participe aussi de la prise en compte de la protection de l'environnement. Plus récemment encore, le Conseil d'État a estimé que le droit de chacun de vivre dans un environnement équilibré et respectueux de la santé, tel que proclamé par l'article 1er de la Charte de l'environnement, présentait le caractère d'une liberté fondamentale qu'il était possible de demander au juge de protéger, même par la voie du référé. C'est une décision des chambres réunies du Conseil d'État français du 20 septembre 2022 qui vient d'être rendue. Avec le développement du droit de l'environnement, les dernières années ont donné lieu à d'autres décisions significatives du Conseil d'État en matière climatique, dans le cadre de son contrôle juridictionnel des actions de l'administration française. L'examen par le Conseil de questions pour l'application du droit climatique est naturellement lié à la ratification de textes internationaux, comme je l'évoquais, et leur transcription dans le droit français en objectifs plus précis. Il s'agit bien sûr de la Convention cadre des Nations unies sur les changements climatiques, déjà mentionnée. Il s'agit également du protocole de Kyoto, de la Convention d'Aarhus et de l'accord de Paris sur le réchauffement climatique, qui ont accru les contraintes qui s'imposent à l'État et qui l'obligent à lutter contre ce réchauffement climatique. Et le juge administratif en est le garant naturel. Plus globalement, le droit de l'environnement présente plusieurs caractéristiques qui me semblent en faire un droit assez original, proche à cet égard et d'ailleurs non sans lien avec le droit de la santé publique. Ces caractéristiques se retrouvent dans le droit climatique. C'est d'abord un droit du long terme, les engagements et les normes votés par le législateur invitant le juge à examiner l'effet de mesures à des horizons lointains, voire très lointains. C'est également un droit où l'incertitude et la précaution sont très présentes, ce qui nécessite une expertise particulière pour le juge ou pour ses aides. Ce droit appelle également le plein emploi des outils à la disposition du juge pour donner un effet utile à ses décisions, en particulier les pouvoirs d'astreinte et d'injonction qui sont particulièrement utilisés en cette matière. Et c'est enfin, à l'évidence, je l'ai déjà dit, un droit qui a un champ géographique qui s'affranchit des frontières. Deux décisions, pour terminer, de la juridiction française illustrent ces caractéristiques et méritent d'être mentionnées, même si je ne vais pas les analyser. C'est le président Reynaud qui le fera avec beaucoup de talent cet après-midi. La première résulte de la saisine du Conseil d'État par la commune de Grande-Synthe et par plusieurs associations, décision du 1er juillet 2021, afin de contester le refus du gouvernement de prendre des mesures supplémentaires pour atteindre l'objectif issu de l'accord de Paris de réduction des émissions de gaz à effet de serre de 40% d'ici à 2030. Et le Conseil d'État a fait droit à ces requêtes. Il a observé d'une part que la baisse des émissions en 2019 était faible et que celle de 2020 n'était pas significative car l'activité économique avait été, on le sait, très fortement réduite par la crise sanitaire. Il a noté d'autre part que le respect de la trajectoire définie par un décret pris en application de la loi n'apparaissait pas atteignable si de nouvelles mesures n'étaient pas adoptées rapidement. Il a donc enjoint au gouvernement de prendre des mesures supplémentaires d'ici au 31 mars 2022 pour atteindre l'objectif de réduction des émissions de gaz à effet de serre de 40% d'ici 2030. Je tiens à souligner que pour les décisions importantes, et singulièrement pour celles concernant le droit de l'environnement, le Conseil d'État observe et, le cas échéant, s'inspire des décisions que d'autres juridictions adoptent dans le monde. Et d'ailleurs, un service du Conseil d'État, le Centre de recherche et de diffusion juridique, que je salue ce matin, est chargé de cette étude pour éclairer les juges et plus particulièrement tous les membres du Conseil qui interviennent dans ces matières. La seconde décision résulte de la saisine du tribunal administratif de Paris par plusieurs associations mettant en cause la responsabilité de l'État en raison de son action insuffisante pour réduire les émissions de gaz à effet de serre. Par deux jugements du 3 février 2021 et du 14 octobre 2021, le tribunal a jugé que l'État n'avait pas respecté ses engagements en matière de réduction de ses émissions de gaz à effet de serre entre 2015 et 2018, causant un préjudice écologique matérialisé par le réchauffement climatique. Le tribunal administratif a ordonné que le dépassement du plafond des émissions de gaz à effet de serre fixé par le premier budget carbone portant sur les années donc 2015 à 2018 soit compensé au 31 décembre 2022 au plus tard. Nous aurons donc l'occasion à cette échéance de l'apprécier. Les décisions du Conseil d'État, comme les jugements du tribunal administratif de Paris, donneront peut-être lieu à de nouvelles décisions, portant bien évidemment sur leur exécution respective. Plus fondamentalement, les questions que pose le droit climatique incitent à un questionnement sur le positionnement, les outils et les moyens du juge, garant du respect des engagements des États. Et ce positionnement est particulièrement difficile, puisque le juge n'a évidemment pas la légitimité dont disposent les autorités élues, ni la compétence technique dont disposent les administrations. Il ne peut en aucune façon se substituer à la décision politique pour, par exemple, préciser quelles sont les mesures qu'il conviendrait d'adopter pour suivre la trajectoire résultant des engagements internationaux et de leur mise en œuvre par le législateur. Le juge est le plus souvent, par sa culture et sa formation, un généraliste qui s'attache à être impartial, à être rigoureux et pragmatique, mais qui ne dispose pas nécessairement par lui-même de savoir scientifique et technique. S'il juge en France au nom du peuple français et s'il s'attache à veiller au respect de l'intérêt général, il ne dispose bien sûr pas des mêmes prérogatives que le législateur qui vote la loi. Pour autant, les outils et les moyens dont il dispose doivent permettre au juge de vérifier lorsqu'il est saisi du respect effectif des engagements pris et des mesures législatives ou réglementaires édictées pour leur mise en œuvre. Il peut pour cela mobiliser ses pouvoirs d'instruction qui permettent, en tout cas en France, aux juges administratifs de diligenter des expertises ou de visiter des lieux lorsque cette visite permet d'être mieux éclairé et de saisir les données écologiques de l'affaire dont il a à connaître. Enfin, pour assurer sa mission sans empiéter sur le domaine du politique, le Conseil d'État dispose de pouvoirs d'injonction et d'astreinte qu'il utilise pleinement, comme je l'ai dit, en matière environnementale. Les décisions mentionnées en sont les illustrations topiques. Il est également possible de citer les décisions du Conseil d'État en matière de qualité de l'air, qui sont voisines de celles sur le réchauffement climatique. Ces décisions ont conduit le Conseil à assurer un contrôle régulier de l'exécution effective de ces décisions, en n'hésitant pas à liquider les astreintes records qu'il avait décidées au profit d'agences et d'associations environnementales, ce qu'il fait tant que ces décisions ne sont pas pleinement respectées. Et vous avez des décisions du Conseil du 12 juillet 2017, 4 août 2021 et 17 octobre 2022, les amis de la Terre France qui en témoignent. Ainsi, au-delà de l'interprétation de la règle de droit, se pose chaque fois, au regard des enjeux transnationaux, la question de l'exécution des décisions et des pouvoirs du juge, alors que les juges ne peuvent ni se faire administrateurs, ni abdiquer le rôle de garant des engagements juridiques des autorités en matière de droit climatique. Les obligations climatiques qui s'inscrivent aujourd'hui dans une crise énergétique liée à la guerre en Ukraine auront des répercussions profondes sur toute la société. Pour le juge, les discussions de ces 2 journées contribueront, j'en suis certain, à alimenter la réflexion. Elles viennent en tout cas à un moment crucial pour le travail des juges en cette matière, et elles permettront de prendre des décisions, j'en suis convaincu, toujours plus éclairées, toujours plus adaptées aux nécessités qui naissent du dérèglement climatique. Je souhaite enfin vous renouveler mes remerciements pour votre présence, remercier également la section du rapport et des études qui, sous la présidence de Martine de Boisdeffre, a contribué au sein du Conseil d'État à l'organisation de ces journées, et à tous ceux qui ont contribué à l'organisation directe, au dossier, à l'organisation matérielle de ces journées qui, je l'espère, vous permettront de mener une réflexion fructueuse pour nous tous. Merci à tous, et cette journée peut ainsi commencer.
Monsieur le vice-président du Conseil d'État, Madame la chef d'unité, chers collègues, nous sommes ravis de pouvoir à nouveau organiser une réunion en personne après 2 ans de nos conférences annuelles en ligne en raison de la pandémie. Bien que les 2 conférences précédentes aient été plus qu'adéquates en termes de contenu, je pense, ces conférences en ligne manquent toujours des contacts personnels qui donnent à nos conférences tant de valeur ajoutée. Nous sommes donc très heureux que le Conseil d'État ait accepté d'accueillir notre conférence annuelle dans ce bel édifice et dans cette belle salle. Le Conseil d'État occupe le Palais Royal depuis 1875 et 75, comme on dit en France, aux côtés de la Comédie Française, et le Conseil constitutionnel et du ministère de la Culture. Donc, la culture juridique à côté de la culture tout court. Je pense qu'un illustre ministre de la Culture que j'ai une fois rencontré quand je faisais plus jeune, évidemment, de la randonnée en Cévennes, a laissé ses traces dans la cour intérieure du palais. À court terme, nous sommes confrontés à la guerre déclenchée par la Fédération de Russie en février de cette année en Ukraine, qui cause tant de terribles souffrances humaines, de destruction matérielle et de dégâts environnementaux. Une guerre qui provoque aussi une crise dans le domaine de l'énergie, de l'approvisionnement alimentaire et du pouvoir d'achat. Espérons que cette guerre se termine bientôt et que la crise qui lui est associée se révèle être une crise à court terme. Nos cœurs sont avec le peuple ukrainien et nous sommes très heureux qu'un de nos collègues d'Ukraine a eu l'occasion de participer à notre conférence. nous lui accueillons particulièrement ici. La crise à laquelle notre conférence est confrontée est une crise de plus longue durée. Au mieux, elle pourra être conquise dans la seconde moitié de ce siècle. Cependant, cela nécessite une action aujourd'hui et demain. Nous laissons d'abord parler la science, puis nous examinons les initiatives politiques au niveau mondial et européen avant d'examiner le rôle des juges dans la lutte contre le changement climatique. Et cela occupera la majeure partie de notre conférence. Je voudrais maintenant inviter Madame Vitna Yukne à parler au nom de la Commission européenne. Mais d'abord, je dois remercier la Commission européenne pour le soutien qu'elle apporte à notre organisation depuis plus de 20 ans maintenant. Et je remercie également le ministère du Climat et de l'Environnement de la Norvège et le service public fédéral de l'environnement belge pour leur soutien au Forum des juges de l'Union européenne. Merci pour votre attention et je cède la parole à mon collègue. Merci.
Merci beaucoup, Luc. From Moliere's language, I'm turning to English. And I would like to greet you all. It's really a pleasure to be here, ladies and gentlemen, honorable judges. My name is Vita Yukne. I am from European Commission and I'm representing my team, so greetings from them all. And I'm very pleased. Thank you very much, Luc, for the invitation to be here. I'm very pleased and honored to be here with you today in Paris. And I also like some symbolism. So being in Paris here is, of course, first of all, very welcome accueil, as you say in French, from la Conseil d'État. Merci pour ça, merci pour cet accueil chaleureux. And it's also symbolic because the EU Forum of Judges for the Environment has been created, conceived in Paris. So I suppose it's very nice after 3 years of break, not seeing each other, for you to find each other in Paris again. Also, the Paris Agreement was signed in Paris, which is a cornerstone, very important document for the climate change litigation. And various researchers point that after the Paris Agreement, the climate litigation boomed, and there is now counted third wave for some members in your report of climate litigation. This is also thanks to the Paris Agreement. So it's very symbolic to be here and very symbolic to reunite with you in this forum. Indeed, the planetary crisis is the defining crisis of our time. This is why the European Commission put forward the European Green Deal as its core priority, because we need to address environmental challenges very, very rapidly. There is no time. It has been mentioned that time is very limited. And there will be no sustainable future and human well-being without tackling the interconnected climate, biodiversity, and pollution crisis. And that is also, we are part of this ecosystem. It also directly affects human beings. Everyone's ability to enjoy their rights to life, health, food, and water depends on a healthy environment. Addressing climate change includes protecting health ecosystems and the multiple benefits the ecosystem services provide. And this July, it's been mentioned that it's becoming more and more pronounced, the right to healthy, sustainable environment as human right. This July, the UN General Assembly recognized that a clean, healthy, and sustainable environment is a universal human right. Ladies and gentlemen, this concerns in particular vulnerable people because they suffer disproportionately from climate change. Here we're speaking about children, women, indigenous people, and local communities who are particularly vulnerable to the climate change impacts and depleted environmental causes. And here I would just like to recall a bit and to mention my unit mission in the European Commission. My unit is now called Unit for Environmental Rule of Law and Governance. So in my intervention, I would like to focus on this environmental rule of law aspect and its importance for tackling climate change and for climate change litigation. I must say that a couple of days ago, I spoke with two honorable people who are here, so Luca and Antonia, and they also explained how they and this forum and judges are founding fathers of the concept of environmental rule of law. So I'm very grateful for that because it's my unit's mission now. I'm very happy to advance it further to my capacity. So when we started to speak about environmental rule of law, it started a bit smaller, focusing on environmental participation in decision-making by citizens, focusing on access to justice, public participation, and good environmental governance. Now it goes further and further, deeper and deeper, and focuses that, first of all, environmental rules which are adopted by legislators are clear, because Vice President mentioned that there is a challenge also for the judges if there are internal conflicts and incoherence between various sets of rules. So rules should be, first of all, clear, and they should be well enforced on the ground by allowing also citizens to participate. And these are fundamentals which I would like to bring forward in this debate, because effective protection of the environment is dependent on this environmental rule of law. And of course, the courts are also more than ever pivotal in Europe and across the globe in asserting the environmental rule of law and bringing the environmental protection to the next level and tackling the climate change. I will not go to comment any of the judgments. There are much more knowledgeable people in this room who will do that. But I cannot avoid mentioning, for example, Urgenta case in the Netherlands, who also looked to what the legislator does, to what the government does, and how they meet their international commitments. Or the case of the German Constitutional Court, which found the Climate Change Act also needs to look to the future generations, not only to those who live today, their well-being, their economic wealth, but also to the future generations. And indeed, these cases in the courts came because citizens acted. They used their access to justice as a tool. So these instruments are very important because without that, cases will not reach the courts. And it's known the nature cannot go to the court, right? Even if we give legal personhood to some natural treasure, nature elements, they cannot go to court themselves. They still need to be represented. So this is why, ladies and gentlemen, it's still important to assert this long-standing principle, which is long-standing principle in EU law, but not even there. It's applied and reasserted in law to the equal and necessary level to have this access to citizens and environmental organizations to be able to bring justice. Indeed, access to justice is the basic foundation of functioning of democratic societies. And civil society needs to have this means to go to the court. This is also a way to increase public confidence in the quality of the decisions which are taken by public authorities in implementing environmental rules. Just from my own camp, the European Union recently amended rules which are based on the Aarhus Convention and concerns internal review mechanism by the decisions adopted by the Commission and other EU public bodies. Now this right to request the EU public bodies for this internal review is much wider than it was a year ago. And it will deepen further in April next year because citizens meeting certain criteria, not only environmental organizations, will be able to ask for this internal review of our own decisions. And this is an important element to keep also checks and balances, because we would know that the lawmaker knows that citizens have this right. So of course, this is an integrated natural element of checks and balances in the decision making. Then also there are various bodies of existing EU environmental legislation which contains provisions on access to justice, because this is in essence to ensure a high level of environmental protection. For example, these are laws, the directives and transposed laws which concern environmental impact assessment, industrial emission, environmental liability. These pieces of instrument also have rights, grant rights to citizens to access, through environmental organizations, to access justice. And also there is assessment by the courts, because in EU, the Court of Justice of the European Union has also confirmed entitlement of environmental associations to bring judicial challenges related to the protection of nature, even if the nature directive did not have a specific provision on the access to justice. So the court also looks at it as an overarching principle. We have the Aarhus Convention, and that needs to be implemented. And then the upcoming new directives proposals will also have a number of them provisions on access to justice. Those which are being negotiated, for example, the regulation against deforestation, the new industrial emission directive proposal, and the recent nature restoration law, they contain such provisions, and the more to come in the area of better air quality and green claims and urban waste treatment directive. So then also we ask the citizens to engage with us to bring cases to the court. But then it's a question also, how do we care what then happens next to them? Do we protect sufficiently environmental defenders? This is another question which underpins environmental rule of law, because we indeed rely, and I speak to various investigators, prosecutors, we receive a lot from civil society. But then what do we do to protect them for this public service which they're performing? And this is why it also comes to the area of EU law. The anti-SLAPP package tabled by the Commission, so the package which aims to protect right defenders against strategic lawsuits against public participation, also covers environmental defenders. The new proposal for environmental crime directive also has a specific provision asking that in the context of criminal procedure to give support and assistance to those who denounce environmental crimes. So that is also important role of us to ensure this protection of environmental defenders. And then I mentioned, say how this rule of law needs to be ensured. It's also very important to send signals to offenders that they would not go easily off the hook if they commit, for example, environmental crime. Then sanctions need to be serious, and consequences should be adequate to the consequences which they cause to the environment and to the human health. So this is one of the topics which in the course of the new environmental crime directive, we're looking at very, very careful to keep this level of deterrence and to ensure better the environmental rule of law. Here, a lot of questions will also come for you, honorable judges, because sometimes, of course, not sometimes, we often give high level definitions. See, for example, environmental crime is something which is unlawful and causes substantial damage. But then, of course, you will need to interpret what is that unlawful, how it goes together. Is there, and just a very brief word about, for example, environmental permits. Can there be permit to kill? If authority gives a permit for some industrial activity and causes mortal diseases to neighbors, can we say that that permit also covers the right to kill? So all these questions still will come to courts and tribunals to answer. And I'm very happy to be part of this reflection and debate. So, ladies and gentlemen, I started with environmental rule of law and underpinning how it is important to build foundations, because what it matters, of course, is not only a bit like thermostat. No politician says 2 degrees, not more than 2 degrees, that's the limit. So it's like a bit this, say, thermostat logic, but that is not enough. We also know that if we only adapt thermostat in our houses, it's not enough to solve the air pollution and other crises which we face. So what I just wanted to say that in my view, I do believe that every case and every step really, really matters, because for these global challenges, the answers is not only big the answers are big and small, so every detail matters. So ladies and gentlemen, with this thought, I would like to thank you for your attention and to say that I'm very much looking forward to your conference. I wish you fruitful debate. And indeed, I believe that the environmental rule of law is largely in your hands. Thank you for your attention.
Merci pour cet encouragement à nos journées de travaux. Avant de donner la parole à ce que la science peut nous dire, je voudrais simplement prendre congé en ce qui me concerne. Je voudrais simplement m'associer aux mots que le président Lavrisen a prononcés tout à l'heure et saluer une nouvelle fois notre collègue ukrainien qui est parmi nous. Merci à vous et donc bonne journée de travail. Ceux qui interviennent maintenant.
So I think it's when we speak about climate change policy, climate change litigation, we should start with seeing what science told us. And we are very happy that Mr. Blas Kurnik, who is the chief of the impact, the group with the European Environmental Agency in Copenhagen, who study the impact of climate change. So please, the floor is yours to give us your scientific insights.
Thank you very much, Mr. President, and thank you to the host to being here, and also to all the participants here to listen me. I'm Blas Kurnik. I'm coming from the European Environment Agency. We are based in Copenhagen. We work a lot with the European Commission, with the European Parliament, but we are also working with our member countries. And the member countries, we are more than EU member states. We also have like Turkey, Iceland, Norway, Switzerland as additional member countries in our network. So I will today discuss and in the next half an hour or so and tell you about what the science is telling us, what the data are telling us about climate change, in particular what the climate impacts are and how to adapt to climate change. I will also touch about to the mitigation side, but I think it's also important to understand where we are with the climate impacts, what the climate, how the climate is affecting us and how the climate will affect us. And this is basically the thread of my talk today. Next slide, please. Takes a bit of time, I guess. Yes. And I'll start with this slide. And you still remember probably about the summer 2022. Basically, a couple of months ago, we have been witnessing an exceptional summer of 2022. We have heat waves across Europe. Also, Paris was very much affected. We also know the picture of droughts, like the Rhine River was basically empty, and forest fires, especially in the southern Europe, especially in the Portugal and Spain, affected our lives. And the question is this exceptional summer or is something which we are expecting in the future? And in very general terms, I would say this was probably in general and in average the coldest summer of the rest of our lives, because it's just getting worse. Next slide, please. And here is, let's say, one slide about the data. And there's basically indicator showing us the temperature in Europe. We all know about the global temperature, Paris Agreement, limiting our temperature to 2 degrees compared to the pre-industrial period. Europe is warming even faster than the rest of the world. And here, basically, you see the European temperature. And you can see that the last 20 years or so, they were all years above the average. So basically every year was warmer than the average in the average period over this period. And this basically shows that, let's say, this is the data until the 2022. The 2022 was not even the warmest one, but we all saw our how they basically impacted our life, because in 2022 we had a combination of various things. We had a very dry summer, we had an extreme heat wave, and we have also the temperature which are getting higher and higher. Next slide, please. And this is also looking a little bit in the past, showing what are the damages and fatalities we have registered in the last 40 years or so. And this is the slide basically showing the graph about the damages. And this is basically the damages which are recorded with the insurance company, and shows that over the last 40 years in Europe, we experienced around 500 billion euros of damages and around 140,000 fatalities due to the extreme weather and climate events. And this is on the lower end, because of course the data which are coming from the insurance companies are usually also biased and not detecting everything. So this is on the lower end, and we are actually experienced already significant damages, significant economic losses, and significant fatalities. As you can see in the slide, the most of the fatalities are coming due to the heat waves. Like almost 90% of all the fatalities registered in Europe are due to the heat waves, and mostly due to the 2 or 3 heat waves in the last 20 years. And one was also very famous and very known here in Paris, is in 2003. Next slide, please. And when we look in the Europe, again, looking into the economic losses and insured economic losses, you can see that the picture in Europe is rather different. On one side, we have Eastern Europe, where we have quite a lot of economic losses, but very low insurance level. So basically, all these losses are quite basically lost to the society, because they are not recovered by the insurance companies. On the Western Europe, of course, losses are also very high because of the economic power is higher, but the insurance level is a bit higher in Western Europe. But still, a lot of economic losses also in Western Europe are basically a loss to the society. In average across Europe, and average around in the last 40 years, we registered that only 25% of all the losses were insured. The rest were lost. Actually, the loss to the public, let's say, and the loss to the public budget. Next slide. When we are looking in the future, I can say you've probably seen these graphs. Europe is getting warmer and will get warmer. Basically, every part and every season in Europe will be warmer than what we are having experienced now. And in particular, when we are looking into the, let's say, geographical distribution, we can see that the Southern Europe will suffer, let's say, the biggest warming in the summers. So basically leading to the more and more heat waves in the Southern Europe, to the drought and water scarcity events. And in the winter, the Northern and Northeastern Europe will be experienced the biggest warming, which means less snow, less water availability and so on, which is coming through the let's say snowpack and so on. So basically, when we are looking into the future, independent of the scenarios, looking into the, let's say, low emission scenario or high emission scenario, the Europe is and will get warmer as we have it now. Next slide, please. But when we are looking into the models, because the future is projected and predicted by models, and the models are basically like all you know, is basically the closest to what we can understand what would be in the reality. But indeed, the models have also quite large of the uncertainties. And when we are looking into the future, we are basically usually playing with 2 scenarios: one on the low emission side, low emission scenarios, and one more on the high emission scenarios, so-called RCPs, RCP 8.5 or RCP 2.6. When we are putting the, let's say, all the what the models are projecting or predicting, and putting next to the observed values, we see that all the models are basically under projecting or under predicting the reality. So basically what we see now, it's actually even worse than even the worst part of the, let's say, the models are projecting. And this is basically in here, see in the black dot, which shows the observed values, and the, let's say, others are modeled, let's say, values for the future based on the, let's say, Paris Agreement scenario 2.6 RCP, or let's say high emission scenario that we actually live and like we are doing now. And that's actually is scaring and worrying, that basically the observed value are above the worst case models. Next slide, please. And of course, this leads to rather few climate hazard or climate impacts. And I will give you a couple of examples, not all of the examples, because they are basically, we can look into the future in projecting different climate hazards. The one I already mentioned before is about the forest fires, looking into the 2 degrees, let's say global warming, let's say that it's something which is close to the Paris Agreement. And what I show in the previous slide shows that basically 2 degrees warming, it's already more or less out of reach. And high emission scenarios, which is looking more on the, let's say, emissions which we are experiencing more or less now, and not looking too much into or mitigating too much the climate change. And you see that basically, of course, the increase of the forest fire, it's visible independently from the scenario. But what is actually more scaring is that the forest fires and the high emission scenarios are appearing also in the regions which are not, the forest fires are not so frequent or actually common at this stage, like the Scandinavia, like Sweden, Norway, and so on. And this, of course, is damaging and will be damaging the quite fragile environment there. Like the boreal forest and so on, which are the essential for mitigating the climate change. Next slide, please. Yeah, another one example is about the heat waves. You know that temperatures in the summer are getting higher and higher. We are experienced, and we have experienced the summer 2022 with very warm temperatures, above 40 degrees for long period across Europe, and this will just continue. So the heat waves in Europe will be, in particularly in the southern Europe, getting longer and more frequent. And this is basically the slide showing the let's say increase in number of days of the heat waves compared to the current situation. Which will go up to, let's say, 50 or 60 days more than what we are experiencing now. And in particular, in the southern Europe, the colors are quite reddish. But if we put, and that's basically the slide next to it, not the slide, the figure next to it, how the cities are built in Europe. So how much of the green space in the city we have. And green space, as you know, if you have a heat wave, you will usually go to the park, you will go to the water, not staying in the dense apartment. The cities in Southern Europe are actually having the lower share of the green areas. And of course, when we combine these two slides, like the number of heat waves is increasing in Southern Europe, and the green areas like parks and waters in cities are basically the lowest in the Southern Europe, this will have a significant effect on the society or the citizens of the cities, because in some cases the cities will not be actually supporting the healthy or the well-being life in the city. And as you know, the urban development is very slow. So basically, we want to change the city, we want to change the city setting, we need to actually start building it now to be prepared in the next 50 years or so. And that's basically will affect the society, will affect the citizens, and of course, especially the most vulnerable population, like the children, like the elderly population, will be, of course, suffering a lot being in the city center in the future in the southern Europe, for example. Next slide, please. And this shows basically this is the graph which basically goes into the past, but we can also project it in the future. It's showing how the vulnerable society or how the basically exposure to the heat waves is affecting the vulnerable society. Because on one hand, the European society is getting older and older. So basically the elderly people are the most vulnerable to the extreme temperatures. And on the second, on the other side, we have more and more increase in the temperature. And you can see quite an exponential rise in the number of people exposed or being vulnerable to the heat waves, which is accumulated now of course, in Europe, reaching more than 200 million over the let's say average period. Next slide, please. Then other aspects, I will just go example of the, let's say, few sectoral examples. And one example here is the agriculture. As you know, agriculture production is mostly happening outside under the clear sky, under the sky, and of course being very much affected by the climate change. And this is the slide which shows the production or the yields of some of the key, let's say, yields in Europe, like maize, sugar beet, and wheat. And in particular, when we are looking in the future, in most of Europe will be showing decreases in the yield production of these key yields across Europe. Of course, in some cases, in the Northern Europe, might be some increases, but this is not accounting of the extreme weather events like a forest fire, like heat waves and so on. It's mostly looking into the average changes of the yield. And as you know, we are already experienced a bit of the crisis in the food sector. On one hand, we had drought in Europe in this year. We have a Ukrainian crisis. Then we have also some of the countries stopping the export of the yield, like India or others, due to the other climate extreme like heat waves or flooding or so on. And of course, when we come to the global market, this can of course have a significant effect to the most vulnerable citizens in Europe, but mostly outside Europe. And of course, when we look in the future, Europe will becoming more and more dependent on the climate, on producing the key yields what we are producing in Europe. Next slide, please. And that's basically also due to the, let's say, various climate hazard. The agricultural land in Europe might also get significantly, let's say, changes in values. And this is the slide. This is again modeling the future, looking how due to the climate extremes, due to the water scarcity mostly and so on, the prices of the land in Europe will change. In particular, in the southern Europe, you can see significant decreases in the land value, which lead that some of the farmers, because of the land will not anymore support them economic activities, will actually have to stop being farmers or stop producing and start doing something else. Of course, this slide also shows the Northern Europe might show some kind of increases in the land value because it will support some, let's say, better development or actually increases in the yield production in the Northern Europe. But this is, of course, not accounting the extreme climate events like, again, forest fire, heat waves, which will affect the Northern Europe as well. It's only looking into the specific, let's say, average climate. But just the message which I would like to give you is that the part of Europe, especially the southern part of Europe, the economic activities which is depending from farming sector will significantly change and will have effect on the society because the farmers will have to start doing or working on something else. Next slide. Another problem in the agriculture sector is also the pests and diseases. And example here, it's coming from Italy, but it can be also example for the Spain, France, and other Southern European, let's say, countries which are depending on the olive oil production. And this is actually quite a realistic modeling, and also already experienced something in the current climate, is that due to the warm winter, the production of the olive oil will decrease because of the development of the pests which are affecting the olive trees. And olive trees, as you know, need decades to grow, need decades to produce, and to invest properly to mitigate the problem of olive oil production, which is quite an important, let's say, sector in Europe, since 70% of all olive oil is coming from Europe. It's basically showing that, let's say, at the end of the century, like almost 80 or more % of the olive trees will be affected, and the production will significantly decrease. The next slide. Another example is on the looking into the sea level rise. As you know, sea level rise is in particularly affecting the let's say the economy of the coastal regions. And when we are looking into the average sea level rise, the numbers are, let's say, by the end of the century, like 1 meter max to be, let's say, increase in the sea level. But when we are looking into the extreme sea level rise, these values are completely different. So we can see that some of the cities in the coastal area in Europe will experience like a 500 times more of extreme flooding than it's actually now. So basically, if the city is now flooded maybe once every 100 years, we can expect in the red values that this can increase by 500 times. So it means that the city, which is like very rarely now flooded, can be flooded and twice a year. And this means that completely restructuring the city protection or the city's infrastructure will need to be done. And again, investing into the urban planning, it's a long-term process, and it's affecting the society. It's very costly, and it needs to be developed and started in the right steps. The next slide, please. And this is basically showing what does it mean, how much of the population is affected if you have an extreme sea level rise of 6 meters, which can happen, even though the average sea level rise is 1 meter, extreme sea level rise can be of 6 meters due to the other conditions. And you can see in this slide, just briefly, this is one of the slides which we modeled in the, or the data modeled in the agency, shows that like 20 or 30 million of people will be affected immediately when we have extreme sea level rise. Next slide, please. So that just briefly, that the whole aspects of thinking or the logic behind needs to be now looking not on the climate hazard side, but we need to start looking into the climate risks. And climate risk is not only accounting the climate, but it's also accounting how the society is changing, how society is exposed to climate change, how society is vulnerable to that. And therefore, we started now looking more in the climate risk assessment, and we will produce a climate risk assessment for Europe in 2024, looking on all aspects of climate change, not only looking in the climate impact side, but also onto how vulnerable society is, how vulnerable environment and economy is, and how it's exposed to climate change. Next slide. Of course, the data is important, and here is just example of how we are delivering data to various stakeholders. In particular, we have a climate adaptation platform, which all of this kind of information can be found, which I presented in. And then we are also looking a lot on the human health, and then we have established the human European Climate and Health Observatory, which is providing data on human health as well. Next slide, please. On the policy side, and this is something which has been already mentioned many times, on the global level, there are a couple of different policies looking into the climate change, in particular climate change mitigation and adaptation. Like we have a Paris Agreement, important, the Sendai framework for disaster risk reduction. It's also looking into how to basically mitigating the impacts of climate change. And of course, the SDG, Sustainable Development Goals, are the, let's say, global framework which we are operating. On the European level, the climate law, already mentioned a couple of times, but it's not only climate law, also regulation, governance of the energy union and climate action. We have EU adaptation strategy, but then there are also other directives which are directly or indirectly looking into the climate change or climate change impacts and adaptation, like the Water Framework Directive, Biodiversity Strategy, Agriculture Policy, and Sustainable Finance. And also we have programs which are dealing with data production, like Copernicus. The next slide, please. When we are looking at the European countries, this is the picture which shows how the countries have been developing their adaptation strategies and plans. Nowadays, all European member states and member countries which we are dealing with have adaptation strategy or plan. But what is missing is the concrete implementation. So basically implementing these strategies and plans into the concrete actions. And that's only, let's say, few countries have developed the climate risk assessment, and only few countries are having sustainable, or let's say, developed the indicators to measure the progress, how good they are in implementing the adaptation strategy. Next slide, please. I'm going towards the end. What is important to say, it's also that adaptation is usually happening at the regional level or the local level, because many times we need to invest into the localities, and many times the local level do not have significant resources or significant manpower to implement the adaptation strategy. So there is a, let's say, one program which is now being developed is so-called Europe missions, and under the Horizon Europe program. And one of this mission is also on climate change adaptation, which is looking into how to support this local, let's say, localities and communities to invest properly to start implementing the adaptation and really building let's say, or start building the proper adaptation actions to protect the environment, society, and economy at the local level. And the next slide, please. So already mentioned a couple of times climate neutrality, and I would like to finish with this slide and the next one. So Europe has now the climate law, which says that we need to be climate neutral by the 2050. Fit for 55 is also being adopted to decrease the greenhouse gas emissions by 55% compared to the 1990s levels. But on the other hand, we also need to have sustainable, let's say, nature to help us, in particularly to increase the let's say, absorption of the greenhouse gas emissions, which we will not be able to decrease, like from the sectors of aviation, some transport sector of industry, which we will not be able to come to zero. And for this, we need to have a, let's say, healthy nature, healthy forest, sustainable agriculture, and so on. And this is basically the graph which shows here how much we will need to also compensate with, let's say, sink of the CO2 by the 2050s, like around 5 to 10% of the greenhouse gas emissions will need to be compensated with that. And that leads me to my last slide. Next slide, please. And for this, we need to have healthy forests. And that's one example which shows, let's say, it's coming from the Czech Republic, but there are also other countries which are actually having the similar picture. It's about forest now being a sink of greenhouse gas or CO2 for many centuries or many decades. But in the last years, due to the climate impacts, due to the sometimes forest mismanagement or the water scarcity due to the other factors, the forest has become also the source of emissions. So we will need to also reverse this trend, that basically the forests we are counting on it to actually help us to mitigate in the climate change, we need to become also the, let's say, reverse the trend to become our support in mitigating and become a sink of the CO2. Last slide, please. Yeah, and then with this, I would like to stop, and in case you have any questions, I will be happy to answer. And thank you very much for listening.
I think we have still 5 minutes for questions, and I would like to start maybe with a question. So looking to your slides with projections for 2100, are they taking into account, let's say, the Paris Agreement or the hypothesis that the parties will stick to their promises, or are those projections on impact on agriculture, sea level rise, impact on city? Is it also the case if we realize the Paris objectives? Thank you.
Yeah, thank you. Slides which I show are mostly looking into the, let's say, the extreme emissions, like the high level emission, not taking into account all aspects of the Paris Agreement. As you know, if you put all the pledges now together, we are reaching around 2.7 degree of global warming by the end of the century, which is above the Paris Agreement. And of course, when we are looking into the future and scenarios which are shown, in particular the high emission scenario, are leading to this kind of extreme sea level rise and extreme, let's say, forest fires and so on. What I've showed before is that actions will need to be taken now, and really drastic actions we need to start to basically reverse the trend, because currently, and slide which I showed it, the observations are even above the most extreme scenario, no? And this is something which is the worrying. But of course, hopefully we will manage to somehow in the next decades to limit the global warming, and of course the trend will start towards the end of the century going down. But even though that if we are fully successful with the Paris Agreement, the next decades, or the, let's say, 50 to 100 years, the climate impacts will still be increasing because of the, you know, the climate inertia and so on and so forth.
Thank you. Are there questions from the floor? I'm looking. Yes, Françoise.
Okay. There are people still who contest the effect of climate change, you know about, of course. How do you address those people, and do you have serious arguments? Do they have serious argument, because they still have an impact in the society, and I know some who try to lobby a lot to the European Commission. And I know personally someone who has written a book. He is an engineer, he works in university, he is a professor, and he is a strong opponent of this demonstration, and he supports oil, continue to use oil.
Yeah, thanks. That's very important point. Of course, the climate deniers or climate skeptics are still there, much less than it was maybe a decade ago or 2 decades ago when I started working on the climate change topics. And I've seen the trends that maybe 10 years ago I've been getting lots of inquiries about, challenging the numbers. Now it's maybe a bit less, but they are still existing. What is important is to basically start showing some, some numbers, data which are coming out from various models. Of course, the models are always uncertain, and it's difficult to basically convince someone who is already convinced about something without having a strong argument. So what is important is have strong, robust data, and that's what we are doing. So basically compiling this data together, which are robust enough. Second thing, having strong scientific arguments and solid basis. And of course, going also in presenting these facts to the non-classical audience. And I'm happy to be here today because this is not the classical audience which we are usually talking to. And it's basically quite important to, through the argumentation, through the dialogue, this is changing, but it's a long process. There will be always few percent of, let's say, climate skeptics. There will always be, also the scientists or engineers, which will be somehow objecting to what is shown. But on the other hand, we are also having quite, let's say, good examples, and I'm saying good examples, which are usually quite bad examples of how the climate is affecting us. And some of the, let's say, extremes which we are now experiencing are unusual. So we haven't been, let's say, in situation of this kind of 2 months of above 40 degrees temperature in the last decades or ever in our lives. But of course, there will be always a clash in the arguments, but I think the honest and open discussion is always needed, and argumentation is always an important part. And also listening to the arguments from the climate skeptics and trying to basically reverse them. That's also important, because the easiest is to say you are wrong. That we should not say it, even though they are. We understand they are wrong. They're 99% of the scientists are basically showing just the, let's say, the opposite picture, but there will be always one which are also the loudest one to basically be, we have to convince them with the argumentation. But I've seen the trend in decreasing of the number of skeptics in my career, which is now maybe 15, 20 years on the climate topic.
Maybe last question for Swatandra Kumar.
You just mentioned about the climate change impact on agriculture. Could you kindly tell us the impact on agriculture developing countries? Particularly, would it be in loss of crops, or would it be total yield going off the field because of the variation of the climate change? And what remedy possibly one can have? Thank you.
Yeah, that's very, very good question. It's both. On one side, there are events or extreme events which are leading to the loss of crops, because there will be, let's say, some of the countries or some of the regions across the world where the crop production will be not anymore, let's say, the classical crop production of some of the crops will not be anymore feasible. So that's one. So basically, and for example, you have example across Europe when they have extreme climate events which are affecting so much the agriculture production that it's not sustainable anymore. And this will be even more in the future, like extreme long-term droughts leading to the desertification will actually stop the crops, let's say crops production, but also, let's say, agriculture production. On the other hand, you have also the quite many examples on how the climate extremes are affecting the yields. And this is, of course, varying from year to year, but also in long term, the yields are significantly decreasing in some parts of Europe. Of course, this can be compensated with a new type of agriculture production, with let's say investing into the new technologies, which are let's say looking into the crops which are more resistant to climate change, or basically changing sustainable the production that becomes more sustainable, like sustainable irrigation. Irrigation is always a bit tricky because if you don't have enough water and investing in irrigation, you can do more damage than basically it has been done just with stopping of the production. But sometimes maybe the harvesting water in the right way, in sustainable way, can lead to let's say stabilizing the agriculture production.
Thank you very much. Now it's time, I think, for the coffee break. We have half an hour, and we will resume 10:45 in this same room. Thank you. Oui. Je propose que on recommence nos activités avec une série de présentations dans ce deuxième partie de ce matin. Et après que la science nous a informé l'état des affaires, nous allons tourner maintenant vers la politique et le droit. Et on est très heureux d'avoir comme première orateur Christina Voigt. Elle est professeure à l'Université d'Oslo, mais elle est aussi présidente de la Commission mondiale sur le droit de l'environnement de l'Union internationale pour la conservation de la nature. Et elle a succédé dans cette capacité l'autre orateur de ce matin, le juge Antonia Herman Benjamin. Mais ce qui est aussi très important dans le contexte d'aujourd'hui, elle est coprésidente du comité de mise en œuvre et conformité de l'accord de Paris. Et donc, elle suit les choses de très près. Elle est presque sur son chemin vers Sharm el-Sheikh pour la suite des négociations. Elle va nous parler de développement récent au niveau international. Donc, Christina, la parole est à vous.
Merci beaucoup, Luc. Thank you very, very much for this kind introduction. Thank you even more for your kind invitation to join your excellencies, colleagues, justices, and the members of the EU Forum for Judges, of Judges for the Environment in this excellent exchange today and tomorrow, which I believe is a very important one, and congratulations to you for having engaged in these exchanges for so many years. Now, as you said, I am going to talk about recent developments in international climate law and litigation. And when I was sitting down to prepare this brief presentation, I thought, ooh, that's a lot to talk about. So I did choose a couple of developments and initiatives. There may be some that I don't have the time to mention, just to give you an idea of what kind of initiatives are out there and are on the steps or on the doors of different courts and different institutions. I will start, I've structured my brief presentation in both looking at some of the legal developments in international discourse with regard to climate change, and then I will look at international litigation. If I have the time, I'll say a little bit about national litigation, but we'll see if we can get there. So I'll start with saying some of the legal developments with regard to the Paris Agreement before I say some words about the recognition of the right to a safe, clean and healthy environment as a human right. And then I'll say a couple of words about ecocide before I then move on to litigation. Now, with regard to the Paris Agreement, we've already heard several times today how important it is as a directing instrument, as the international treaty, which now has been ratified by 195 parties. It is something that has been very frequently cited and used in climate cases, in litigation, both as an interpretative element, but also in those cases where states have adopted national climate acts, climate laws directly implemented in domestic legislative frameworks. The one element in the Paris Agreement, which is maybe the most frequently cited or used, is the goal of the Paris Agreement. And we've all heard about the temperature goal several times today. It's sometimes referred to as 2 degrees, 1.5 degrees, but it's important to be concise. And I thought it might be helpful to have a look at what the agreement actually says, but also what the recent development in addition to it was last year at the climate summit in Glasgow. Now, we have a decision by the Conference of the Parties from last year in Glasgow, which gives a bit more indication of where this global goal on temperature is headed. What we see is this in the Paris Agreement itself, we have this formulation, which I'm sure you're all familiar with, which talks about holding the average temperature to well below 2 degrees. That's very important. It doesn't say 2 degrees, but well below 2 degrees. It was very important when we negotiated the Paris Agreement to recognize that 2 degrees is the threshold that should not be crossed. And for that reason, that buffer was put in there that is now included in the words well below 2 degrees. For political reasons, also the temperature goal of 1.5 degrees was included, as we all know. Now, what happened last year in Glasgow with the adoption of the Glasgow Climate Pact by consensus by all parties to the Paris Agreement was that both Article 2 of the Paris Agreement was reaffirmed, but that is important, it was also recognized, and that goes along with the previous speaker here today, that the impacts of climate change will be much lower at a warming of 1.5 degrees compared to 2 degrees. And therefore, the Conference of the Parties resolved to pursue efforts to limit the temperature increase to 1.5 degrees, which means there is a normative shift of consensus from well below 2 degrees to 1.5 degrees, so much stronger emphasis on 1.5 compared to 2 degrees. That is very important to recognize in the use and interpretation of domestic laws and action in the light of the Paris Agreement. The second important outcome from the conference in Glasgow last year is also a time-wise anticipation of when parties have to act and when they have to reach the moment of crossing to what was called climate neutrality around 2050. The agreement itself in Article 4 talks about drastic emission reductions so as to achieve a balance between anthropogenic emissions by sources and removals by sinks in the second half of this century. This balance between emissions and removals is the same concept of as climate neutrality. We just weren't able to put that terminology in the agreement. But what came out of the of the conference last year in Glasgow is an anticipation from the second half of the century to around mid-century. So we have to be seeing an earlier crossing or trajectory to climate neutrality around 2050, and not just in the second half of this century. So these are two developments, normative developments, that I think are important to recognize. The second legal development that we're currently seeing, or normative development, is, and I think previous speakers already commented on that, the recognitions within the UN system of a human right to a clean, safe and sustainable environment. And we had from 2021 the recognition by the United Nations Human Rights Council, which recognized that the right to a clean, healthy and sustainable environment is a human right that is important for the enjoyment of human rights. I'm sorry, that's the next slide. So that was a very important recognition in 2021. One resolution later, we also saw the establishment of a United Nations Special Rapporteur on climate change and human rights. That's the gentleman which is on top. The gentleman below is the United Nations Special Rapporteur on Environment and Human Rights, who of course celebrated the resolution at the United Nations Human Rights Council last year. Since then, next. And the next. Since then, we've seen also the United Nations General Assembly recognizing that right, but in a slightly different manner. The General Assembly in June this year recognized the right to a clean, healthy, and sustainable environment as a human right. It did not add the remaining part of that sentence that is important for the fulfillment or enjoyment of human rights. It stopped at that recognition as a human right in its own way. Next slide. Here I just copied and pasted for you the wording of that resolution by the United Nations General Assembly. Now the question is, what are the legal, next slide. You're probably all familiar with how the voting went in New York. I just included it here for reference. Next slide. The question is, what are the legal repercussions of these recognitions by the Human Rights Council or the General Assembly? Now, both of them are not legally binding. We know that. But it is probably fair to say that the legal status is something a little bit different from the legal consequences of these resolutions. We have these resolutions and they can be used, and they will be used, I'm sure, by probably also many of you in this room here, in order to strengthen national constitutional provisions of the same nature, where constitutional provisions, and we have about 100 or more than 100 countries that already recognize such a right in their domestic constitutions, and where that international recognition can be used in order to strengthen the national recognition of that right. But we also see that we have many international human rights treaties that not yet have any reference to environment or climate change, where it may come helpful as an interpretative guide when existing human rights, for example, Article 2 or Article 8 of the European Convention, who do not speak about the environment, could be interpreted in taking into account the environmental conditions for states that need to exercise their positive obligations. And in that interpretative process, maybe the recognition by the Human Rights Council and the General Assembly can come in helpful. By the end of the day, right to a clean, safe and healthy environment, if it becomes justiciable, will have to rely much on the work of the courts, on judges, in terms of defining the concrete actions needed, the threshold of harm, and so forth. Next Finally, on international legal developments, there is, as you perhaps are aware of, a global initiative to include the most severe environmental harm in the list of international crimes at the international level, with the objective of criminalizing environmental harm. The purpose here is to include ecocide or environmental harm as a fifth international crime in the Rome Statute, which established the International Criminal Court. And it is something that would have to lead to an amendment. Now, we haven't seen this amendment yet, and we don't know whether that's ever going to happen. But what we've seen is that since the Stop Ecocide Foundation, chaired by the then Chairman Polly Higgins, she passed away a couple of years ago, since the initiative has become a global initiative and has engaged an international panel of lawyers to provide to provide a definition of what ecocide could mean. We've seen many debates in national parliaments, national initiatives to seek to include ecocide or the criminalization of environmental harm within their national legal framework, with penal codes or criminal codes. One slide, please. Next slide. The definition launched only last year is the one that you see here on the screen, where ecocide means the unlawful or wanton acts committed with knowledge that there is significant or substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. And only the launch of that definition last year has led to significant discourses and debates and considerations within several countries on the meaningfulness and likelihood of including ecocide or environmental harm in national legal frameworks. Next slide. It may be a long process on the international level, but as I said, the discourse alone can lead to a shift and change in consciousness, and even maybe to a shift and change in domestic criminal codes. That in itself might already be a success of the initiative, because it is, by the end of the day, the prosecution which has to have happen at the national level, which is the most effective in order to address most severe environmental harm through criminal law. Next slide, please. Now, let me move from legal initiatives, legal developments to international litigation. And here we don't really have that much yet, but we have a rising tide of initiatives, literally, of initiatives that seek to engage supranational courts and treaty bodies and tribunals in order to address different questions with regard to climate change and international law. The most recent development, perhaps, is a finding by the United Nations Human Rights Committee just about a month ago, where the United Nations Human Rights Committee found that a group of minority citizens of Australia, these are minorities that live on the Torres Strait Islands, which belongs to the territory of Australia, were violated in their rights to life, private life and cultural life under the ICCPR. And the Human Rights Committee found that Australia violated those rights by not taking timely and effective adaptation measures. That speaks to your point, primarily by not building seawalls fast enough and high enough. By not doing that, the own government violated the human rights of those indigenous minorities. This is, to my knowledge, the first international recognition of the link between human rights violations and climate change impacts, here through insufficient adaptation actions by Australia. Second point, next slide, I'm sorry. We all know, and it has been mentioned several times today, that the European Court of Justice, and I think we're going to hear probably a bit more about this throughout those 2 days, is asked in 5 instances now to adjudicate on the link between human rights and climate change, primarily mitigation action or insufficient mitigation actions. None of these cases has been decided yet, but of course it's a very, very interesting development to see all these cases coming to the European Court on Human Rights. And of course the expectations are very high to see what the court is going to say, in particular with regard to interpreting Articles 2, 3, and 8 of the European Convention in the context of climate change, primarily mitigation obligations of the parties to the European Convention on Human Rights. Some of these cases, in particular the first one and the fourth one, also consider extraterritorial obligations, which may be an additional very interesting aspect to follow, but they're not yet decided. Next slide, please. 2 initiatives which I thought might be interesting for you to know about. Initiatives that seek to engage the highest courts, the International Court of Justice and the International Tribunal on the Law of the Sea, to render advisory opinions with regard to states' obligations on climate change. First, the initiative that seeks an advisory opinion from the ICJ, the International Court of Justice. It's an initiative that is spearheaded by Vanuatu, but Vanuatu has recently been joined by CARICOM, and it seeks, as I said, an advisory opinion from the ICJ, and the resolution to engage the General Assembly, which would need to put that request to the ICJ, I think is tabled for today or tomorrow at the United Nations General Assembly. So we'll probably hear a bit more about or know more about it by the end of the day or tomorrow, whether this is going forward or not. The question that is most likely going to be put to the ICJ, if the initiative goes forward, concerns the obligations of states to protect current and future generations against the consequences of climate change. Next slide. And a similar initiative, also spearheaded by a small island developing state group. Here it is Barbuda and Tuvalu, now recently joined by Palau, taking a parallel initiative to seek an advisory opinion from the International Tribunal on the Law of the Sea in Hamburg, in order to seek a clarification about states' obligations under the United Nations Convention on the Law of the Sea, in particular Articles 192 and 194 that deal with the protection of the marine environment, and to what extent states have obligations under UNCLOS in order to protect the marine environment against the impacts of climate change. UNCLOS is 40 years old. It was adopted in 1982 at the time where climate change was not high, if at all, on the international agenda, but it is a living instrument, and it may be very interesting to consider how the provisions of the United Nations Convention on Law of the Sea have evolved over time, and also take into account climate change obligations. This commission, it's called the Commission of Small Island States on Climate Change and International Law, was established last year in the margins of COP26 in Glasgow. And the sole objective primarily of this commission is to seek an advisory opinion from ITLOS. Next slide, please. This is just a copy of the agreement for the establishment of that commission. And you see in paragraph 2, Article 2, paragraph 2, that it shall be authorized to request advisory opinions from the International Tribunal for the Law of the Sea, ITLOS. Next slide. I would like to round up my presentation, and maybe that's a good segue to most of the discussions that will follow later today and tomorrow about trends or interesting aspects that seem to come out from national climate litigation. I won't go into much detail. I just want to highlight these 6 concepts or principles that have been used and are being used by different courts, both in Europe and outside Europe, which may be interesting to consider and to note at least the application of these principles. And for each one, I'll mention a case. First is the use of a duty of care, which several courts have more or less successfully applied, both in relation to climate obligations of governments, but also private actors. The second one is the temporal extension of freedom rights, intertemporal application of rights that we've seen. Fourth one is the principle of non-regression, which also has been paralleled by the application of the principle of progression. And then we have the application of in dubio pro natura, extraterritoriality, and rights of nature. And let me just briefly say put one case to each one of these principles. Next slide. So the duty of care applied to both private actors and governmental actors is something that we've seen in the Netherlands, both in the Ogenda case, but also in the Shell case, where based on an unwritten duty of care in the Dutch Civil Code, in the tort part of the Dutch Civil Code, it was found that both the state but also private actor have a duty of care to reduce their greenhouse gas emissions in line with the Paris Agreement, in line with science, in line with human rights obligations, and several other interpretative elements. This duty of care is based on what is regarded as proper social conduct. So it's a very wide term, which of course allowed the court to interpret it by taking into account all these different parameters. The second one is this aspect of intertemporality, the extension of when we look at rights infringements that was applied by the German federal constitutional courts in the Neubauer versus Germany case, where it was found that certain freedom rights of, in particular, younger people, it wasn't future generations, it was younger people that live today, that have rights today, but their rights may be infringed in the future by putting the most or the heaviest burden of climate mitigation action on them, pushing everything into the future, would infringe their right to certain freedoms under the German constitution through processes that have been set in motion now. And the court argued that their freedom rights have to be protected on an equal basis between now and in the future. And that led to a revision of the German Climate Protection Act. Third element here is that element of extraterritoriality, which of course climate change being that global challenge that crosses boundaries, both in terms of contributions, but also effects of climate change, is something that we see more and more of in the context of litigation as well. An interesting decision here by the United Nations Committee on the Rights of the Child, also from last year, which was dealing with a complaint by several children, young adults, against 5 member states of the United Nations Convention on the Rights of the Child. And in that case, the Committee on the Rights of the Child found that claim inadmissible because those young claimants did not exhaust national remedies. But it continued saying that the provisions of the Convention on the Rights of the Child apply, and they would actually have to be interpreted to protect those children against the impacts of climate change, means that those states need to raise their ambition and protect those children against the impacts of climate change, and not just the children in their own territories, but also children that live elsewhere. So there was a very profound and direct application of the extraterritorial extension of human rights obligations. And the last slide, where we have a fairly recent case from Mexico, Court of First Instance in Mexico, that had to deal with the reversal of licenses to set up renewable energy projects, both a wind and a solar project, and instead gave a license to another oil refinery, I think it was. And in that particular case, which was brought by Greenpeace against the government in Mexico, that court of first instance found that this is a regression from a previously established level of ambition in climate policy. And that regression from what already was achieved was something that the court said was violating both in dubio pro natura. It was violating the principle contained in Article 4, paragraph 3 of the Paris Agreement, and it was in violation of consideration of future generations, just by rolling back initially published licenses. And finally, an interesting development that we see in several courts worldwide, but also in legislative efforts, is the recognition of rights of natural elements in their own right, rights of nature, where rivers or lagoons or national parks are considered as subjects and holders of rights rather than objects. We have an interesting case from the Supreme Court of Colombia where the Colombian part of the Amazon was considered to be a right holder and a subject of right, which is not just an empty term, but it corresponded to obligations and duties of the government to maintain, protect, conserve, maintain, and restore the forest, the Amazon, at least in Colombia. So these are developments that we are seeing, where we see the use of these concepts put forward in order to enhance climate ambition by governments or companies, but also to protect against regression from levels of protection where we already are. And the final slide just says, thank you.
Merci, Christina, pour ce panorama de la politique climatique au niveau mondial, aussi les affaires, la jurisprudence qui, au niveau global, mais aussi national, qui commence de se développer. Maintenant, je propose de tourner notre vue vers l'Union européenne et on est très heureux d'avoir parmi nous Isobel Finlay. Elle est chef d'unité adjoint, coordination stratégique, juridique et institutionnelle dans le DG, donc le directorat général de l'action pour le climat de la Commission européenne. Et elle nous parlera des initiatives très importantes récentes, la nouvelle loi climatique, mais aussi les discussions en cours pour finaliser le programme pour réduire les émissions avec 55% pour la fin 2030. Isabelle, vous avez la parole.
Merci and good morning, everybody. Yes, as was said today in my presentation, I will give an outline of the EU's framework on climate, and in particular the recent developments culminating in the European Green Deal, which is the mandate of the current Commission. And also what this means concretely for the ongoing revision of the EU's climate acquis. I have a set of slides which I think Farah will kindly will kindly operate on my behalf. Perhaps just as a word of introduction on the historical context for the EU's climate legislation and policy, it's very useful, I think, to have had the initial presentations on both the scientific basis of climate policy and also the international framework, because the EU's legal framework on climate has very much developed along the lines of the multilateral process, which was established under the United Nations framework on climate change, under which the Paris Agreement was adopted. And also our policies and legislation are very much based on science and scientific developments. So just to see if the slides are coming, or
Will they come, or
shall I
do we need some assistance?
Okay,
It will come.
so maybe I'll just continue and then. So yeah, in terms of the background to the European Green Deal, this was a concept established in the political guidelines of the current Commission President, who was selected by European leaders and elected by the European Parliament in 2019 with a 5-year mandate to run until 2024. This was one of her key priorities, to make Europe the world's first climate neutral continent by 2050. So that is essentially the central aim of the European Green Deal. I understand that in the previous presentation on science, there's been some discussion about this concept of climate neutrality, which we define largely as a balance between reduction of greenhouse gas emissions and on the other hand, the contribution of removals, so carbon sinks, in order to reach this climate neutral target. So that's the central aim of the European Green Deal. It's perhaps also worth understanding a bit the way and a bit the speed in which our targets have developed in the EU, because we started at a point in the early 2000s, so around 2008, where we set an initial target of reduction for 2020 of minus 20% against a 1990 baseline. We then, looking ahead to 2030, European leaders agreed in 2014 to increase the target for 2030 to an at least 40% reduction in greenhouse gas emissions, again based on this 1990 baseline. Nevertheless, because of the increasing focus on climate policy and really the recognition of the need to act faster, the context of the Paris Agreement being adopted in 2015, we're already within the decade looking at revising our existing 2030 target. And so that is another key element of the European Green Deal in order to reach this pathway of climate neutrality by 2050. There's a recognition that already we need to move faster to 2030. Perhaps just one other point on this slide is to say that the European Green Deal in the EU is a whole economy approach. And so it's very much key to being able to reach this target is for all sectors of the economy to make a contribution to reaching this target. So the next slide, we'll start to look at what is the legislative framework in the EU that we have introduced in order to put into legislation these aims that we have. And with that in mind, the Commission made a proposal in March of 2020 for a European climate law regulation. So you can see on this slide sets out really the key targets that we put in place in this European climate law proposal. First of all, an EU-wide objective to achieve climate neutrality by 2050, together with an aim to reach negative emissions after that date, and that's set out in Article 2.1 of the climate law. And then, as I've said, in order to provide a realistic pathway towards achieving this objective, it's necessary to increase the existing 2030 target from this -40, at least 40%, to an at least 55% net target of emission reductions. And within the law, we also introduced a review framework to enable us to review and revise the existing legislation in order to achieve this. Also on the pathway, the European climate law makes a provision for the Commission to propose a 2040 target. And we will do this in line with the review provisions, which are also contained in the climate law, which we'll come on to explaining a bit further as the slides go on. But I think it's also useful to understand that our review cycles in the climate law are intended to be aligned with the international process. And so under the Paris Agreement, there's what's called a global stocktake process, whereby the intention of the parties is to review on a 5-year cycle the contributions of parties under the agreement, and whether the parties are on track to reach these global goals under the Paris Agreement. And so we have, in the EU, we have aimed to align our review processes in our legislation to align with that international process under the global stocktake. So moving on to, so on this slide, perhaps just to highlight a couple of other elements. So we have the targets and we have the review provisions. And then also we have a number of other provisions, including a role for adaptation, which is another very important policy element of climate policy. And then also the public participation elements of the climate law, which I'll come to. And then also just to say, why overall is the climate law important? And I think it's really this idea that putting it into legislation makes sure that our path to 2050 is irreversible. So we have it in legislation. It then gives a clear investment signal, a clear signal of how the economic transformation that's needed, and also an international signal of the EU's commitments to making its appropriate contribution under the Paris Agreement. So moving on to the next slide, just a couple of words in more detail about the 2050 objective itself. So this is within Article 2.1 of the Paris Agreement, and the law itself contains this definition of net zero, which, as I said, is this balance between emissions and removals. It's also important to mention that it's an EU-wide objective and also an economy-wide objective, so all sectors of the economy to contribute. Also, it is to be achieved domestically within the EU. So this means without recourse to international credits, which can be available under the Paris Agreement. And then, as I've said, also an aim for negative emissions after 2050. Just briefly on the next slide, there's a graphic here which shows the the trajectory which needs to be achieved moving to 2050, and also an important principle of EU climate policy, which is to decouple emissions reductions from economic growth. So we have seen over the past decades that it's been possible to increase the GDP of the EU overall, whilst at the same time reducing emissions. And this is a very important economic basis of the EU's climate policy. Moving on to the next slide on the new 2030 target. So just a few words on that. Again, it's a net target, so having a contribution also of carbon sinks removals to the overall target. Again, it's also a domestic target within the EU. During the negotiations on the climate law, the European Parliament, as one of the co-legislators, also wanted to prioritize emissions reductions within the 2030 target. And so there was an agreement to reduce for 2030 the contribution of removals to that target to overall within the EU a 225 million ton CO2 equivalent. Nevertheless, we also are bearing in mind the longer term perspective to 2050, and therefore we have a proposal on land use and forestry, which would aim to look ahead beyond 2030 to increase that contribution over time. Moving on to the next slide. So yes, so what the European climate law provides for is the new 2030 target. But in order to deliver that within the EU, we have to, as the Commission, we had to look across the board at all our climate legislation to see how the legislation would need to be reviewed and upgraded in order to deliver this new target, which is in effect, given that we're already within the decade to 2030, is in effect a doubling of the existing target. So it's a very ambitious pathway that we're trying to achieve within the decade. I'm sure quite a number of you are aware of the centrality of the EU emissions trading system to the overall climate acquis. We'll look at this in a bit more detail on a later slide, but the emissions covered by this system constitute over 40% of all emissions, greenhouse gas emissions within the EU. It's an EU-wide scheme which covers primarily the power generation and industry sectors. And so that's a substantial part of the package of measures that we're currently reviewing. Then on the other side, we have what we would call effort sharing, which is those sectors of the economy which are not covered by the emissions trading system and are roughly a bit over 50% of all emissions. And there we have a mixture of EU targets and EU measures to try and achieve those objectives, together with member states having national measures to meet those targets. So moving on to the next slide. The next slide is just briefly showing you a range of different policy measures which are needed in order to meet the 2030 target across the economy. So then moving on to the next slide, which is the 2040 target. So here, as I said, in the European climate law, we link our review process into the global stocktake under the Paris Agreement. And the first review under the climate law will take place next year in 2023. And then the climate law provides that after that, in the first half of 2024, after that first review, the European Commission will come forward with a target for 2040. So moving on that trajectory from at least 55%, which is 2030, climate neutrality 2050. So for 2040, we have to come up with a proposal along that trajectory, which will enable us to achieve that overall objective for 2050. So we will be doing between now and 2024 a very comprehensive set of analysis, which will go along with a legislative proposal to amend the existing European climate law to incorporate as the Commission what we would propose as the target for 2040, which will then be, of course, subject to negotiation by the European Parliament and the Council. Just on the next slide, just to mention that the European climate law also includes provision for the Commission to publish an indicative greenhouse gas budget. So this is in a way another way of kind of calculating the trajectory to mid-century, which we see in some national climate laws as well, is in addition to having an emission reduction trajectory, also expressing what's required in terms of total volume of net greenhouse gas emissions, which we believe are available between now and 2050, which we can actually use without putting at risk our commitments under the Paris Agreement. And so that is something that will be published indicatively along with the 2040 targets. Then on the next slide, obviously one key element for the EU is how do we stay on track between now and 2050. So as I've said, the European climate law it's an EU-wide target. So it's a collective objective that we have to reach climate neutrality by 2050. And therefore we have key provisions in Article 6 and 7 of the European climate law to make this provision for periodic assessment of our progress, both at EU and member state level, to take stock of our progress towards these objectives. The provisions that we have build on an existing framework under another regulation, which is the EU governance regulation on energy and climate. So we've also tried to align with that existing framework. And as I've said, the first progress reports will come next year in 2023. Briefly, just to mention on the next set of slides, some of the other elements that we have under the climate law, aside from obviously the targets and the assessment of progress. So as I've said, the climate law also gives an important recognition to the role of adaptation measures in our overall EU climate policy, particularly to adapt to the effects of climate change. And this was actually the basis for a new EU adaptation strategy, which we published last year. Then on the next slide, we have We have also a provision to ensure that within the better regulation process that we have within the Commission across all legislative initiatives is to incorporate a climate consistency check into that, so that for all initiatives that the Commission is considering adopting, no matter what the area, the policy area, the climate law provides that there should be a check on the consistency of those measures with the climate neutrality objective. So this is something which we've incorporated from the climate law into our better regulation processes. We also have, there was talk earlier of the climate pact at international level, and we also have a climate pact at European level, which is a key component of public participation and citizen engagement in the overall European Green Deal. And this acts as an EU-wide platform and forum for the exchange of information, ideas, and best practice on EU climate action. So this is also something recognized in the climate law. Finally, the climate law also establishes an EU scientific advisory board on climate change. And the idea is to have independent scientific advice and reports on EU measures and their coherence with the climate law. The Scientific Advisory Board has actually just recently been established following the adoption of the climate law. It's hosted by a secretariat under the European Environment Agency, but the board itself acts independently of the agency, and 15 senior academics, experts across a range of disciplines have been appointed for an initial four-year appointment. So their work has just started, and their work program has recently is in the process of being developed. So those are the main elements of the European climate law. And moving on just to talk in a bit more detail about this current legislative package that we have, that is currently being negotiated by the European Parliament and the Council, which we informally call it Fit for 55, because the idea is to deliver this new at least 55% target through this comprehensive revision of the EU's legislative framework on climate. So just moving on to the next couple of slides. So we, in September of 2020, when we were considering an increase to the target, we prepared an impact assessment known as the Climate Target Plan, which sets out how the 2030 target can be achieved across all of the sectors of the EU economy. And it's very much the case that the principles of fairness and cost efficiency are really underpinning this impact assessment and are the key to how we want to deliver on this revision. So just on the next slide, there's that shows you an overview of all the measures which are contained in this legislative package, which was adopted by the Commission in July of 2021. So it's, as I said, it's currently it's in the process of being negotiated by the European Parliament and the Council as the co-legislators. It contains It contains a kind of policy mix of measures. So there are revisions to existing legal acts. There's the introduction of some new additional measures. And there's a range of, essentially a range of regulatory pricing targets and financial support measures to implement this target, which I think we can see on the next slide. So I think, as I mentioned, the emissions trading system is the key pricing measure that we have within our climate key. Then there's also, which we'll come on to look at, there's also regulatory measures, so direct introduction of direct targets in certain sectors, and some financial support measures as well to achieve this target. So looking just in a bit more detail at the individual proposals, first of all, on the emissions trading system. As I said, it's a cap and trade system, which covers almost half of the EU's emissions, covering over 10,000 installations, and also aviation emissions. It's actually a system not just for the EU, but the European Economic Area as a whole. The basic way in which it works is that there's a cap, there's an overall cap on emissions, which is reduced annually. And as I think I said before, it's an EU-wide system where allowances are generally auctioned and traded on a market. There are a certain number of allowances that are allocated free to certain high-performing installations in sectors which are at risk of what we call carbon leakage. So that's where there's a risk of there being lower standards in third countries, and therefore a risk of not being a level playing field. And the ETS directive sets benchmarks for how such allowances can be allocated for free and to which installations. The proposal that we made in July 2021 would revise the existing ETS directive to deliver a -61% increase in the ETS sectors, which compares to the existing -43%. So as I've said, the discussions are currently ongoing as to what will be the final percentage. But you can see in any case, this is a very significant upgrading in the existing contribution of this system. We propose also within this, we propose to phase out over time free allowances which are given to the aviation sector. We also propose to include maritime transport within this system. And then separately, we propose a new separate ETS system on roads and buildings, which would complement existing regulatory measures in this area. Because one of the trends that we've really seen is that, particularly in the transport area, it's one sector where emissions have been increasing as opposed to decreasing. And therefore, it was clear that additional measures would be needed in order to try and address emissions in those sectors. So what we intend here is for this new ETS to sit alongside existing regulatory measures that we have at EU and national level in those sectors. On the next slide, just to mention that the new ETS for roads and buildings, there were obviously in the consultations leading up to the proposal, there were a number of concerns raised about the impact of citizens, in particular of having pricing measures in these sectors. And therefore, the Commission has proposed a social climate fund specifically to accompany this new ETS, where member states would be able to disperse funds in order to fund plans and projects to help to reduce emissions in those sectors. So, for example, renovation measures for buildings, energy efficiency measures, and so on. In terms of the budgetary architecture of this fund, this is something, again, which is under discussion by the co-legislators. What we propose is to set this up within the budget of the EU and have it reflect a percentage of the expected revenues from the auctioning of allowances in those sectors, which would be 25%. Nevertheless, we will see what is the actual architecture agreed, but that was our initial idea in terms of how to fund this. And I think the next slide shows as I said, the kind of measures that we would envision that member states could fund within social climate plans that they adopt in their own member states. So just moving on to if you like, what I called the effort sharing side. So that's those sectors which are not covered by the ETS. We have on that side, we have an effort sharing regulation, which contains the national targets per member state. And overall, we have proposed to increase those national targets to increase the overall contribution of effort sharing sectors to -40%. So the existing contribution under the existing 2030 target is -29%. So again, it's a fairly significant increase for those sectors. We also propose, as I mentioned, we propose an updated LULUCF regulation, which is quite a complicated acronym that we have, which describes the legislation in the land use and forestry sector. So there we propose to increase the contribution of carbon sinks, so removals, to the 2030 target. And again, we propose to set targets per member state, which would amount to an overall EU contribution of 310 million tonnes CO2 equivalent. In this LULUCF proposal, we also have proposed an overall climate neutral land sector by 2035. We will see within the course of the negotiations whether that's something that can be agreed by Parliament and Council. You can imagine it's a rather contentious area because you're talking about the forestry and agricultural sector where there are quite specific challenges. So we'll see whether that's something that remains in the final legislation or not. The next slide here, we actually have a slide on which shows the effort sharing target per member state, and you can see in the blue the existing target, and then the green the additional target. The key kind of measure for setting this is GDP per capita. So in general terms, those higher income member states are expected to make a greater contribution, but we also have a cost efficiency kind of indicator within that to ensure that for each member state, it also reflects their potential to reduce emissions on a cost efficient basis. Just looking then at some of the other proposals finally within this package, which are intended to deliver the targets. So on the next slide, we also have a regulation governing CO2 emissions from cars and vans. So here we propose to increase the existing targets so that we can move towards zero emission vehicles by 2035. There's very much now the technology is moving quite fast in this area, and therefore we really want to make sure that the EU's regulatory framework is moving alongside that, so that we can have targets that can assist and stimulate that technological change in those sectors. On the next set of slides, we also just to mention some measures which are a bit outside the remit of DG Klima, but which are also part of this package of Fit for 55 in other sectors. So first of all, of great importance is of course energy. So here the Commission proposes to increase the existing targets for renewable energy to 40%, and then also to increase energy efficiency to within a range of 36 to 39%, which I think is on the next slide. Also very importantly is to look at when looking at the transport sector, is to make sure that we have the necessary measures in terms of fuel regulation and also infrastructure measures to go alongside the targets. So in particular, for any targets towards zero emission in the transport sector, you can imagine that it's very important to have in place the charging infrastructure across the EU in order to be able to implement that in an effective way. And therefore, we've made a proposal for setting quite ambitious charging targets across the EU by 2030 to go alongside the new measures on standards. In terms of taxation and trade, these are also important elements. So in terms of, we're also looking at revising the existing energy taxation directive. What I would say is that this is a rather more challenging kind of instrument for us to implement at EU level, because it's something that requires unanimity in the Council, so it requires all member states to agree. And this is also, I think, partly a reason why the emissions trading system has developed in such a substantial way over the past couple of decades, because it really sits as an alternative measure to national or EU taxes, which are much more challenging, as I've said, to implement at EU level. So it remains to be seen. The negotiations on this proposal are rather slow in the Council, so it remains to be seen how much progress can be made there. Then perhaps just to mention one final measure that's kind of on the climate trade axis, which is this this idea of a carbon border adjustment mechanism. So as I said in a previous slide, the existing ETS directive contains measures to try to protect those sectors that are particularly at risk from international competition, and perhaps from imports of products where the standards are lower. So as part of this package, the Commission has come up with a proposal for a carbon border adjustment mechanism, essentially to be initially rolled out in certain selected sectors. The idea is very much to align with the EU emissions trading system to make sure that this is part of the overall environmental measures that we're trying to introduce, and to avoid a situation that industries receive double protection, which would not be in line either with our own climate policies or indeed with international trade policy. So there would be a corresponding phase out of free allocation in those sectors which would be covered. And the idea would be to have these CBAM certificates which would mirror the price of allowances under the EU ETS. So it's very much a system that would be aligned with the EU ETS. So that's a bit just an overview of the measures that we have under this Fit for 55 package. As I said, we're currently in quite intense negotiations between the Parliament and the Council. We're hopeful that at least a large part of this package can be agreed before the end of this year, and that we can work towards the adoption of the actual legal acts already in early 2023, particularly because, as I've said, we're doing the first progress report under the climate law later in 2023. So that's just an overview of the existing EU climate framework, and yeah, just a thank you from me to finish off. Thank you very much.
Merci Isabelle pour nous introduire en détail d'une part dans la loi climat qui est déjà en vigueur et d'autre part toutes les mesures qui sont comprises dans le paquet législatif 55 et qui sont maintenant dans une discussion finale pour voir ce que cela va donner en termes définitifs. Bon, c'est un paquet impressionnant de mesures pour arriver à cet objectif de réduction de 55%. Et bon, on peut finir dans notre discussion sur l'un et l'autre aspect. Je suis très heureux maintenant de voir ici mon ami Antonio Herman Benjamin. Je pense que je l'ai rencontré la première fois il y a un peu plus de 20 ans à Johannesburg. Il était seulement encore procureur, je pense, oui, procureur à Johannesburg, où le programme des Nations Unies, ensemble avec la Cour constitutionnelle de l'Afrique du Sud, organisait la première grande réunion pour le judiciaire sur la protection de l'environnement et le développement soutenable. Et depuis lors, je pense, on est resté en contact. Il est devenu juge dans la Cour suprême, on peut dire. C'est la combinaison entre le Conseil d'État et la Cour de cassation au Brésil. Et elle était tout le temps restée très active dans le programme judiciaire dans le contexte du programme des Nations Unies pour l'environnement. Il est devenu aussi le président de la commission the World Commission on Environmental Law. Et puis, c'est la raison pour laquelle il est ici, il est aussi la personne qui a vraiment créé l'Institut mondial judiciaire de l'environnement, qui est maintenant formalisé. Et donc, la conférence est aussi organisée en collaboration avec cette Global Judicial Institute on the Environment. Donc, Antonio, the floor is yours.
Thank you. I know I am between you and lunch, but not so bad because there is a final speaker after me. First of all, I'd like to thank both the European Union Forum of Judges for the Environment, my dear colleague and friend, Justice Luc Lavressen, and the Conseil d'Etat, the other partners for hosting us here in Paris. Those that come from civil law countries know the importance of this court in the formation of the legal culture in our regions. So it's a great privilege to be here, being myself in the public law grand chamber of my court, which is the Conseil d'Etat Juge in Brazil. I would begin with a little bit of historical perspective. It's so obvious, but often we judges need to remind ourselves of things that are very obvious. And to me, this particular aspect is relevant because it shows, to begin this conversation and this reflection in 20 minutes, how the context of climate law and environmental law are different vis-a-vis us judges. In environmental law, judges were latecomers. At first, the expectation was that the administrative state would take care of environmental law. So we judges were not even part of the conversation. We were not even considered. But very soon it was realized that the regulatory state or the administrative itself needed somebody to make sure that it would comply with the new obligations that were established, not just for private individuals and corporations, but to the state itself. It took 10 years, and in some countries, 20 years for the judges to realize that we are part of that, of this regulatory circle designed to protect the environment. With climate law, is precisely the opposite. Because we are being invited to be actors, not just in the implementation of a system that is already designed, both internationally and nationally, but we are invited to something that is still in the process of design. And of course, this brings immense opportunities, but at the same time, immense risks for us judges. As opposed to legislators, they can approve a law yesterday, and then today they have a few drinks, change their mind, and they enact another piece of legislation the next day. With us judges, we have something that ties our hands. It's called res judicata. We decide, and depending on the legal system where we are, after 2 years, you cannot change that anymore. So a new case would have to find gaps in what the facts or the legal theories that were used in that previous case. And that's just one of the risks of being part of something that's still in flux. And even the finest legal minds in this area, like Professor Christina Voigt, still cannot tell us for sure, go this way, and there is no cliff in front of you. She tries, but she's not very convincing sometimes. She doesn't try. She alerts us, you know, be careful. So this is the difference, or one of the main difference. And we judges have to take this into consideration. It doesn't mean that we should close our doors and wait until the legal system is fully formed, because by the time this happens, without our help, whatever was supposed to be protected by this legal system might be already damaged to a point of irreversibility. And we judges are not God. What are the main challenge for us judges? And I said in 20 minutes, I can only select a few and propose them as a way to start a conversation. We should start from the very beginning. We have our colleagues here talking about the very complex aspects of climate science or climate law, but for us judges, where is the beginning? And the beginning is with legal theories that we inherited from ages, from the Romans, the atmosphere. In this country, in the late 18th century and the early 19th century, when the civil code was being discussed, and possibly in some of the rooms here, the atmosphere and all res communis were, in fact, there was a group of scholars said, no, let's not put this into the civil code, because this is nothing. It cannot be appropriated. It cannot become a bien juridique. So not part of private law, not part of the civil code. And now here we are, a couple of centuries later, and we are saying, no, wait a minute. The atmosphere is not only a bien juridique, but it is an existential bien juridique, absolutely crucial to the whole legal system, because it has to deal with the survival of humanity, but also the community of life. And we are invited to change all this in a matter of 20 years. Or 15 years. This is a fragment of time for us judges. We don't count our time in years. We count our time in decades, in centuries. The other difficulty, but don't think I'm taking a pessimistic approach here, but it's important that we realize where the difficulties reside. I will end up with an optimist tone. The other difficulty, and this is pervasive globally, and in common law, in civil law system, in Islamic system, in Sharia, everywhere, our jurisdictions are based in the notion that the territory has to be split. So we are not judges, with the exception of the national judges like me and several that are here, but we are not judges of a whole territory. and let alone a judge of the whole world, exercising national jurisdiction, but with impact in the whole world. We work with small jurisdictions. We split ecosystems. On one side of a river, the riverbank belongs to a judge. On the other side, it belongs to another judge. It can be another country. And this, of course, is precisely the opposite of what we need to deal with legal issues that go beyond the jurisdiction of a particular judge. And in that, from that perspective, now taking into consideration climate change, the difficulties are enormous. The victims might not be there. That would already be problematic because we judges love having the victims there. The attachment to the victim. Well, some of us don't have any attachment, but most do. We like seeing the people that we are supposed to be protecting. But second, the causes of the problems that we are facing might not be there. And third, and this is terrible for us judges, we want to be seen as useful, that the parties involved leave our courtroom either happy or unhappy because something happened. But a lot of what is done by us or can be done by us, the results will be felt in the future. And not tomorrow, not in 1 month, in 5 years, but in 50 years or 100 years. Judges are creatures of the past. That's our zone of comfort. We look to past actions. That's why we are not so good with prevention, and that's why we're even worse with precaution, because our zone of comfort is the damage that is there, be tangible or intangible, and of course with climate change is precisely the opposite of all that. Finally, among those changes, there are others, but then unfortunately I don't have the time to explore. We, as judges, are familiar with a set of remedies that have been with the legal system forever. And we tend to believe that those remedies were almost given by God. We forget that they were creation of legislators or even us judges. And with climate change, as Professor Christina Voigt would have explained if she had more time, particularly in mitigation, the new remedies are really new. And they are not only new because they have different names or different provisions in international agreements, but because the point of departure is different. Different paradigms. So again here, we are called to move away from our comfort zone in the area of remedies. With adaptation, and I'll say more about adaptation later on, the transition is not that complex as it is to mitigation. But even now, at this stage in my presentation, it is important that we understand that we cannot be climate judges if we only look at adaptation. And that's probably the area where we would feel that, you know, I know something about it. Because we have to focus on the causes, and the causes can only be addressed in a direct manner through mitigation. And that's the most difficult area for us judges, and that's why we need to discuss this much more than we have done up to this point. Now, the big question. What's our role as judges? As the Chief Justice, our host, it's a pity that he's not here, but I'm sure you get the message from my colleagues that are here with us. He mentioned in his opening statement that judges, by definition, even the specialized ones, are generalists. Absolutely true. Even an environmental judge can be, and most of us are, generalists, because it's what we are expected to know is now absolutely complex. It's the universe, so to speak. He also said that we judges lack technical competence. That was an act of sincerity done by the Chief Justice. And it's absolutely correct. In spite of those two statements by the Chief Justice, I think we all agree that there is no way that judges can be just spectators of the climate crisis that we live. And there are at least 4 reasons for that. One is pragmatic. If we don't do it, who will do it? Are we trying to invent, or can we invent another institution to replace judges in deciding fundamental questions, existential questions of humanity? Perhaps it's too late for this type of invention, because we are pretty much settled. Just look around. Second, the ethical argument. We judges decide about everything in life, including life itself. When life starts, when life ends, we decide about love. How can we ethically justify that a crisis that put humanity and the community of life at risk, that we judges will just wash our hands and do nothing? When the legal system itself is being redrafted from constitutional provisions all the way to administrative regulations in order to incorporate those concerns of humanity. And as Professor Foyt mentioned in her presentation, new universal rights are being approved by the Human Rights Council and by the General Assembly. Finally, the legal theory argument and the policy argument. And with those two, I address some of the comments of the Chief Justice, the correct arguments. The policy argument, that's a matter for the other branches of government. Well, first of all, it's not the other branches in plural, because if Parliament legislates, it legislates for somebody to implement. And the somebody is us, the judiciary. Second, with judicial review accepted in all over the world, and in this country with the Conseil d'Etat system, it's our duty to control what one, in fact, the other two branches in the constitutional courts, what the other branches of government are doing. either through action, but even more important, through inaction. My final point: the lack of expertise is not a real challenge for us. Because if it were, we should stop deciding cases of intellectual property, DNA. We can barely manage our laptops. And we are deciding major cases dealing with the most complex issues of software. We have experts. We have the power to bring those experts. Good science. Look, do I have 2 more minutes? Because I have already, I was hoping that they would speak less than the 35 minutes they had. So a little bit would be left for me, but in fact it was. Because I only have 20 minutes. So 2 more minutes. Now, in my conclusion, I believe that the most important task that we have now, in addition to the changes in the regulatory framework, international, national, subnational, from an abstract perspective, is to work on the development of new principles. And by development of new principles, I mean not just coming up with completely new principles, but, and we are great in that, in revisiting old ancient principles and adjusting those principles to new challenge and new reality. Professor Voigt, and we didn't discuss it, already mentioned the indubio pro natura principle, and we could have a whole seminar on the indubio pro natura principle. Non-regression. I will mention 2 other ones that to me are absolutely critical to climate law. This is the country where at the beginning of the 20th century, a professor called Léon de Guy, in fact, it was his student, the Swiss, unfortunately died so young in the First World War, the student, his student, developed the concept of a social obligation inherent to property rights. That's probably the most revolutionary legal concept, not just in public law, but in private law as well. Because at the end of the day, it goes to the pillar that brings us together, or in fact, it separates us in different categories. People with land, people with property, and people without land and without property. And later on in the 70s, 80s, and 90s, we developed the ecological function to property rights. I think it's time to announce here in Paris at the Conseil d'Etat that property has a climate function as well. Private property, but public property as well. I think it's a tribute that we can pay to Léon de Guy and to the French scholars that helped law being modernized, both public and private around the world. My very last point is on biodiversity. This is an event on climate change, but we are not handicapped judges. We are judges that understand the absolutely existential threat of climate change, but at the same time, we recognize that we are the guardians of the protection of the Garden of Eden, of biodiversity. We will be handicapped and we will not succeed if we just look at climate and we don't do our duty, which is in fact less difficult because the tools are there and we have been with those tools since ancient times, and protect the diversity of life. Thank you, Luc, for giving me 4 more minutes. Thank you.
Merci, Antonio. Et on a encore quelques minutes après pour la discussion, après que notre dernier orateur de ce matin, c'est Divya Shaula Jindal. Elle travaille pour la Banque européenne pour la reconstruction et le développement. Et récemment, cette banque a fait une étude sur le contentieux climatique en Europe ou dans l'Europe qui est couvert par la banque. Et peut-être sous l'inspiration de son bon collègue de Asian Development Bank, qui a un programme de formation judiciaire très important. J'ai l'impression que la Banque européenne de reconstruction et de développement is going in the same direction. So the floor is yours.
Thank you, Judge Luke. Good morning, honorable judges and distinguished guests. It's very unnerving to have to speak after such eminent panelists, but I'm going to try and make this useful, and you'll all be pleased to know I'm only speaking for 10 minutes. So please bear with me, and I'm going to get started. Can we have the first slide? So I just wanted to start with a very quick introduction about the EBRD for anybody who is unfamiliar with us. We're a multilateral development bank and we operate in the countries that you can see on the screen. Regionally, we're focused on Central Asia, Europe, and the Southern and Eastern Mediterranean region. And within Europe, we're focused on Central Europe, the Baltic states, Southeastern Europe, and East Europe. So what does the EBRD do? Next slide, please. So we are a bank and we do, of course, provide financings to our countries of operation and our private sector clients, but we have a very strong mandate on sustainable development. Our constitutive document enshrines an obligation on the bank to work towards sustainable development and make environmentally sound investments. So as a result of this mandate, we're actually the first multilateral development bank to declare that we will make all our operations aligned with the goals of the Paris Agreement by early 2023. And while we're all still discovering what Paris alignment means, the bank has had a first stab at this and developed a methodology based on which we will assess all our operations, whether it be technical support programs or loans or investments based on how they align with the goals of Paris. And it's also a result of this sustainable development mandate that we engage in policy dialogue and technical assistance activities. Next slide, please. So that's where my team, the Legal Transition Program at the bank, comes in. We help in delivering the bank's policy dialogue and technical assistance work. And we do this in a number of ways, such as helping countries draft laws and regulations, helping set up independent regulators, such as in the energy sector, and also through organizing capacity building activities for public institutions and courts. The Legal Transition Program has been organizing judicial capacity building for a long time. And in that sense, it's not following the ADB, but it is following the ADB, I suppose, because now we're looking at more climate-focused training. But as such, our judicial capacity building has been ongoing since 2005. I've set out the countries where we have completed projects and ongoing projects, and you might find your country on the screen there. More than 600 judges have participated in these programs and have benefited from them over the years. Traditionally, our focus has been on commercial laws, such as mediation, arbitration, IP, and insolvency. But we do believe that it's now time to start thinking about more climate-focused training, like our colleagues at the ADB have done in the Asia-Pacific region. Next slide, please. So I think this I'm just going to go through our thinking behind developing this program. There's, of course, the rapid increase in climate litigation, which needs no introduction. And it's also not just the volume of the increase in climate litigation, but also the variation in the sort of cases that are now being brought. So traditionally, we had cases which were more focused on permitting for specific projects or disputes under the EU emissions trading system. But now with the implementation of the Paris Agreement, it's become possible for litigants to actually question the adequacy and enforcement of climate commitments by state and non-state actors alike. And in some cases, they're also calling for the enhancement of these commitments. Climate and sustainability related regulation is also evolving. We've heard about that this morning from Isabel about what the EU is doing. There's, of course, the Fit for 55 package. There's also the EU Sustainable Finance Package, which is now making ESG reporting mandatory rather than just a nice to have. And we also expect a greater number of cases to be filed against directors and boards of companies once the Corporate Sustainability Due Diligence Directive comes into play, because that will place legal obligations on directors to think about the environment and climate and social related consequences of their decision making. I'll talk about the last point on that slide first, because I think that makes more logical sense. Because the types of cases that are being brought are so varied now, and the arguments that are being brought are more creative, there's also going to be increased regulation. And we expect that in a number of instances, courts will decide or interpret new regulations and laws in the coming years. Maintaining uniformity and predictability of decision-making becomes that much more important. And we believe through focused climate-related capacity building, that can be made possible. And finally, knowledge transfer. And that's quite an important aspect of why we think it's important to do this kind of training. We know that climate-related cases have so far concentrated in certain jurisdictions, but it's only a matter of time before we see this in other jurisdictions as well. So we would like to bridge any gap in terms of knowledge or resources or training for jurisdictions which haven't seen these cases yet, by involving judges also from jurisdictions which have already seen such cases, whether or not they are from the EBRD countries of operation, because we believe that kind of knowledge and resource transfer can be really useful for judges. Next slide, please. And with that in mind, as Judge Luke said, we undertook a study of climate litigation related trends. I won't bore you with the study because I know we have a presentation by the Grantham Institute, and that's a really, really helpful report looking at climate litigation trends. So I'll talk about the next step that came after we did the study on climate litigation trends, and that was actually developing a judicial capacity building curriculum. And I've outline that on the screen so you can see very high level what we're thinking of doing. We've developed this while working with international and comparative law experts. And we also had the benefit of the study we did and of the study that the Grantham Institute publishes on climate litigation. And you will see that we have both an international focus and a domestic law focus. Even though we are going to be doing this training at a national level for our countries of operation, we still think that it's really helpful to see at a high level the international framework on climate. That's only an indicative list you see on the screen. There's, of course, a lot more multilateral activity that would need to be covered. But it's important to see at an international level what objectives and obligations are being placed on state parties under these frameworks. And then, because now there are a number of climate litigation cases that relate to human rights arguments, it would also be important to see what is the interplay of the climate framework with obligations derived from other areas under international law, like environment and human rights related laws. And that's where the domestic or regional focus will also come in. As we heard this morning, the way the framework in the EU is developing is influenced by the international multilateral framework. And that's why we think it's important to look at the domestic context while after first looking at the international frameworks. And this overall study of domestic and international framework is supposed to set the context for actually looking at climate litigation cases. So this is where we think this curriculum would be fairly unique, because we want to involve modules that actually dissect climate cases and look at these based on a range of factors, such as what are the types of arguments that are made, what legal instruments are invoked, how scientific evidence is being dealt with, and whether any substantive or procedural hurdles arise when these cases are being heard. I'd like to say here that even though this training would be done at a national level, we do think it's helpful for judges to see how jurisprudence is evolving in other jurisdictions as well, which is why we would include international and regional case law in the modules dealing with climate litigation. And I'd also like to quickly touch on scientific evidence by saying that we do see this as a really important part of the curriculum, because dealing with scientific evidence and managing it can be challenging. So we would look at this not only in the context of the case law analysis, but also as a standalone subject where we can look at reports of other organizations which have delved into this further, like UNEP, the IPCC reports, and also reports of the International Energy Agency and the European Environment Agency. That was a very quick summary of what we're planning to do as part of this curriculum. And on the penultimate slide, I've set out some factors that we think are critical for actually implementing this program. And I think the most important one on the slide is the sustained support from the judiciary and national judicial authorities. And I'm going to, with apologies, I'm going to specifically pick on senior judges here, because I believe senior judges can really help shift the mindset when it comes to this sort of capacity building and inspire their more junior colleagues and the legal community as a whole to have an interest in the climate focus and take part in this sort of training. And finally, we would also not look at doing this alone. We are definitely looking at collaborating with other institutions that are respected in the judicial community. So for us in Asia, we would look at partnering with the Asian Development Bank, which already has a successful judicial training program on climate. And for Europe, we would, of course, look at support from the EUFJE when we roll this out in Europe. And from all of you, I hope to hear your feedback on this program over the coming days and speak to many of you about it. We'd really like to hear more from you, especially in terms of whether you feel we've missed something, or you feel that there's things that we haven't thought about, or potential challenges you feel in terms of implementing this program. Or also if you think your country would be interested in receiving this sort of training program, or you would like to be involved. So I hope to speak to many of you, and thank you so much for your attention.
Merci Divya pour cette introduction sur les activités en cours de la Banque européenne pour la reconstruction et le développement. Je pense qu'on a encore un petit quart d'heure.